pleasant day to all our law students across the Philippines. I am Kyle Roger Agadan from PUP College of Law, your host for today. And welcome to the Central Book's Best Pre-Week Ever. Our pre-week bar lecture series is a discussion of all the codal provisions and latest jurisprudence as decided by the Supreme Court. This is presented to you by the Central Books in partnership with the Philippine Association of Law Schools, Polytechnic University of the Philippines, PUP College of Law, and Association of Law Schools of the Philippines, Nationality. This is just one of our many lectures for the Central Books Best Pre-Week Ever lecture series, as we also have those for political and public international law, commercial law, taxation law, criminal law, civil law, labor law, and legal and judicial ethics with practical exercise. All this happening in September 2024. Like and follow the Facebook page of Central Books to remain updated with the dates and the speakers of each program. We would also like to recognize our main sponsors from these initiatives, Central Books, and our main collaborators, PALS, PUP College of Law, and ALSP National. Let me introduce to you our esteemed lecturer today for civil law. Attorney Vincent Albano III is the youngest of the late Dean Albano's children. He has been part of the academe ever since he became a lawyer in 2007. In the process, he has authored several books of various titles in the subject of civil law, consisting land titles and deeds, commentaries, and jurisprudence on sales and lease, partnership, agency and trust, credit transactions, and conflicts of laws. With the death of Dean Albano, he has also taken the challenge of continuing the legacy the late Dean started, to be of service to the academe. Let us all welcome Attorney Vincent Albano III.
Hello to all. This is my lecture for civil law. My last minute tips for the 2024 bar examinations that will be taking place on September 11, 8, 9, 10, 11. Tama, 11. So, I hope to impart to you some last-minute reminders on areas that you should focus on for the 2024 bar examinations chaired by Justice Lopez. So, this is my gift to all of you. I hope that patok tayo because I focused on just a few areas in this short lecture, and I hope that I will be able to hit a lot in this lecture. So let's start because my time is short, so we have to hurry up also. Okay, of course we have to start with Book 1 on persons and family relations. So when we have the bar examinations in civil law, it is always a given that persons and family relations make up a lot of questions. I heard from one lecturer in persons and family relations that this area usually takes up at least 40, even 50% of the bar examination questions. So that's why we need to have a good discussion on this area. So of course, with Book 1, we have to start with the provisions on persons, diba? Before we proceed to family code. And of course, yung aking primordial na area that I want you to focus on is yung ating nationality principle, as we could see in Article 15 of the Civil Code. Laws relating to family rights as well as to the status, condition, legal capacity of a person shall be binding upon him even though living abroad. This is an area that I hope that you will be able to remember because it may seem na yung ating Article 15 is not is a simple provision, so to speak, pero it's littered with some traps, so to speak. Kumbaga maraming booby traps itong Article 15 that it may seem to you na walking along this field of Article 15 is easy, but it's not. Kasi it has a lot of correlations that we have to remember. But of course, let's start with Article 15, yung nationality principle. As mentioned, laws relating to family rights and all of these matters are binding upon a person even though living abroad. So when we say that it's binding upon a person even though living abroad, I always like to refer to an OFW as the example for Article 15 as a general rule, whereby, of course, even though somebody or an OFW or even just a person on vacation goes abroad, the phrase "what happens in Vegas stays in Vegas" may be the phrase that comes to mind to the person when he goes abroad, meaning to say, I can do whatever I want abroad. Well, maybe so. You can do whatever you want abroad, but it's important for you to remember that the laws of the Philippines relating to family rights and duties, as well as to the status, condition, and legal capacity, shall be binding upon you even though you are living abroad or just staying abroad for vacation. So meaning to say, if you get married, what will happen if you are already married in the Philippines? That will not be effective, so to speak, meaning to say you will be guilty of bigamy. As we could see in this 2014 case of Lavadia versus Luna. What happened in this case? A lawyer, the irony, di ba? A lawyer went abroad to South America in order to get married. And this lawyer, when he went to South America to get married to his paramour, well, of course, he was already married to his wife in the Philippines. So complications arose, of course, when the lawyer died, because there became two families that were now claiming on his property, on his estate. So, syempre, the Supreme Court reverted back to the general rule, whereby the law relating to your family rights as well as to the status, condition, etc. of the person shall be binding upon you even though living abroad. So, meaning to say, even if this lawyer got married abroad, cannot escape Philippine law. So, yun lang yung point natin dito sa Lavadia versus Luna. How about itong case ni Simundak Kipel, a 2019 ruling of the Supreme Court? In this case, what happened? A Filipina nurse went to Germany and became a naturalized German citizen. So when this Filipina nurse became a naturalized German citizen, she got married to a Filipino. Well, you could see how it went, di ba? Para bang yung Filipina na nurse became a German and then she also got married to a Filipino. So okay, when she got married to a Filipino, she went home to the Philippines. But before coming home to the Philippines, nagkaroon sila ng divorce ng Filipino. So what happened? What happened in this case? There was a question later on lodged by the Filipino as to whether or not they are still married ng Filipina. What did the Filipina-German in this case? What did the Supreme Court say? The Supreme Court said that they are no longer married, yung Filipina-German. Why? Because the Filipina had already changed her citizenship from Filipino to German. That is why she could now secure a decree of divorce. So, in the same way that Article 15 binds Filipino citizens, they also bind nationals of another country. That is why alam naman natin yung case ng Del Socorro versus Van Wilsem. This, after several years of us waiting, was finally asked in the bar exams last 2022, if I'm not mistaken. So of course, we know what happened here in the case of Van Wilsem. Basically, Van Wilsem got married to a Filipina, secured a decree of divorce, and then was sued for support later on when Van Wilsem made the mistake of going to the Philippines to get married to another Filipina. So the Filipina sued him for support. Anong sabi ni Van Wilsem? Sabi ni Van Wilsem, because the Filipina and the Dutch Van Wilsem were no longer married to each other, sabi ni Van Wilsem, you cannot sue me for support because I already secured a decree of divorce against you. So tama naman, sabi ng Supreme Court. What was the problem encountered? The problem encountered was there was a child between the two. So meron silang anak. The question, will the lack of an obligation to extend support to the wife be also applicable to the former wife, be also applicable to the child? The answer was no. Sabi ng Supreme Court, kasi ang main defense ni Van Wilsem dito sa case na to, in order to attempt to deny his child support, is that according to my national law, if I am, meaning to say Dutch law, if I have already secured a decree of divorce against my wife, then I am also exempted from providing support to my children also, which in this case was one child. Diba? Sabi ng Supreme Court, by reason of public policy, that is not available in your favor, Mr. Van Wilsem. So yun yung sabi ng Supreme Court dito. By reason of public policy. So sabi ng Supreme Court, even though as a rule, laws relating to family rights are binding upon you even though living abroad. Kasi nga sabi natin, it binds the Filipino in as much as it binds the German. In our case of Simon Dactipel, yun yung sabi rin ng Supreme Court dito sa Van Wilsem, yun din ang general rule natin. But it does not apply in order to deprive the child of support because by reason of public policy, the Supreme Court wishes to keep the support upon the child present, even though there has already been a divorce decree secured. So Article 15, as we all know, always is correlated with Article 26 on mixed marriages. So we all know how it goes, diba? The most famous case, of course, is the 2018 case of Republic versus Manalo, whereby after securing a decree of divorce in Japan by agreement between the parties, there was this question whether or not the divorce decree secured is valid, number one, and number two, whether or not the divorce decree secured by the Filipino himself or herself in this case was valid also. So sabi ng Supreme Court, yes. Number one, the divorce decree shall have an effect of nullifying the marital relations between the two parties. Because why? Because sabi nga ng ponensya dito sa case na to, there is no reason for distinction. So sabi ng Supreme Court, for so long as the marital relations have been severed by means of a proper proceeding recognized by the law of the country where the divorce was secured, then it shall be considered severed also in the Philippine setting. And also, when we talk about whether or not the Filipino can be the one securing the decree of divorce to begin with, the Supreme Court is also clear on the matter when it said that there is no clear distinction as to why, if it is the Filipino who secured the decree of divorce, that it should not be allowed, meaning to say that the divorce decree should not be recognized. Sabi ng Supreme Court, wala namang sinabi ang Article 26 ng Family Code na kapag halimbawa Filipino ang nag-secure ng divorce, hindi recognized as valid. Sabi ng Supreme Court, as long as the marriage is mixed, whether originally Filipino to begin with and then later on became mixed marriage, once the divorce decree has been secured, whoever the party, whether the Filipino or the foreigner who secured the decree of divorce, okay lang. Sabi ng Supreme Court, there is no substantial distinction between the two. Kaya sabi ng Supreme Court, yes, there is no reason to conclude otherwise. So another provision that we have to remember in persons is Article 17, whereby we are aware of Article 17, Paragraph 1 and Paragraph 2. Basically, the forms and solemnities of wills, contracts, and other written agreements or public instruments shall be governed by the law of the place where they are executed. Yung ating lex loci celebrationis rule. But what I want you to take note of in this provision is Paragraph 3, involving prohibitory laws concerning persons, their acts, or their property, or those which have for their object public order, public policy, etc., shall be binding upon the person. Shall not be affected by any conventions or judgments agreed upon in a foreign country. So what do we mean to say? Let's go back once again to that case of Van Wilsem. Ano ba yung nangyari dito kay Van Wilsem? Sabi ni Van Wilsem, there is a law in my country which provides that I am no longer obliged to support my child once there has been a divorce decree secured with my spouse. So where does that fall into? It falls into Paragraph 3 of Article 17 of our Civil Code, which provides that prohibitory laws concerning persons or their property. So sabi ng Article 17 of the Civil Code here, even if you have a law in your country providing that you are no longer obliged to support your family once divorce has been secured, Article 17, Paragraph 3 provides that it shall not be binding upon Filipinos who seek refuge under Philippine laws. So yun yung long and short of it. So basically, aside from public policy, we also have Article 17, Paragraph 3 to support our ruling that Van Wilsem is obliged to support his wife, his child, even after the divorce decree has been secured. And we also have to remember the case of Bank of America versus American Realty Corporation, a 2000 ruling of the Supreme Court, which provides that if, for example, a foreign suit has been instituted in one country and there is an attempt to split the cause of action in another country, meaning to say there is a foreclosure of mortgage in London that has been instituted in this case, and then a suit for sum of money filed in the Philippines. That constitutes splitting of a cause of action. So what did Bank of America say when American Realty Corporation said that you cannot file a separate suit for sum of money and a separate suit for foreclosure of mortgage against me? So ang sabi ng American Realty Corporation, you cannot file such a suit because it is splitting of the cause of action. What did the Supreme Court say? Tama, Mr. American Realty Corporation. You cannot split the cause of action and then thereafter, after splitting the cause of action, say that it is valid under my laws. Kasi anong sabi ng Bank of America dito? Sabi ng Bank of America, which was registered in UK, kaya kumbaga kaya London ang base na London based ang bank dito. Sabi kasi ng Bank of America, I can split cause of action in London. So sabi ng Supreme Court, that may be true in your country. But in the Philippines, splitting of the cause of action is allowed. And henceforth, if we are going to look at Article 17, Paragraph 3 of the Civil Code, prohibitory laws shall not be rendered ineffective by laws in a foreign country. So yun yung ibig sabihin natin. So those are the two cases that we have to remember in Article 17, Paragraph 3. Just because our chairman loves criminal law, honestly, he was not my professor during the time that he was not yet disqualified from teaching because he is now a Supreme Court Justice. But I know for a fact that he loves criminal law. So it's important for us to remember Article 29 of your persons. Basically, when Article 29 states that if a judgment has been rendered based on reasonable doubt. Meaning to say, it cannot be proven conclusively that you committed the crime, but it also cannot be concluded that you did not commit the crime. Hence, there is reasonable doubt. You can still be sued for sum of money accordingly. So we have to remember Article 29 of the Civil Code because we all know the truism that one who is criminally liable shall also be civilly liable. So always remember that regarding Article 29 of your Civil Code, for so long as you have been acquitted based on reasonable doubt only, and the trial court or even the Supreme Court did not say that you were definitely not guilty of the crime, you can still be sued civilly for the criminal act that you committed, but you were just not convicted for. So yan ang natin, Article 29. We also have to take note of Article 36 of the Civil Code on prejudicial questions. What do we have to remember with prejudicial questions? With prejudicial questions, a criminal case can be held in abeyance until such time that a civil case has been decided. So that is the principle of your prejudicial questions. We have to take note of this. And even though it was asked in the last bar examinations, I still want you to take note of the case of Pulido, the 2021 ruling of the Supreme Court. We are familiar. I hope you are familiar with what happened in this case. A person who was below the age of majority got married to his teacher. So basically, that's true. Yun yung facts nitong Pulido. This person, excuse me. Yun siguro. So this person below the age of majority got married to his teacher. And then what happened? So basically 17 years old siya at the time he got married. So 17 years old siya at the time he got married. As a lesson to all of you, we all know how it is when you get married early. You will still undergo that phase ng pagkabinata at some point. And in this case, Pulido was no exception. Nang babae si Pulido, and unfortunately, he also got married to another woman once again. So, when he got married to another woman, what happened? Wife number one filed bigamy suit against him. In this case, the Supreme Court ruled as follows. There is no longer a need for you to be declared, or for the first marriage to be declared as null and void ab initio before a criminal case can be dismissed against you, in this case for bigamy. Why? Because sabi ng Supreme Court, because sabi ng Supreme Court in this case, it is true that the marriage is null and void ab initio. And number two, yung ating Article 40 of the Civil Code states that a need for judicial declaration of nullity of marriage is only required for purposes of remarriage. So hindi naman sinabi na for purposes of acquittal in a criminal case, you also need to secure a judicial declaration of nullity. So yun yung effect ng case ng Pulido. There is no more need for a judicial declaration of nullity before you can be considered as, before you may be acquitted for your bigamy suit. But remember, Pulido in this case was underage when he got married. So that's not applicable to you, law student who is already 25 years old, di ba? Hopefully, 25 pa lang or if older, di ba? So yun yung tanda natin sa case ni Pulido. We also have to remember this case of Kiambao versus Osorio. An administrative case is prejudicial to a civil case. So when we refer once again to Article 36 of your Civil Code, we can see that prejudicial questions only involve criminal cases, but in this 1988 ruling, the Supreme Court applied it also to a civil case, basically an administrative case being prejudicial to a civil case. So what happened in this case, there was a suit for sum of money filed against a director of a corporation. What happened? There was a suit to dismiss there was a motion to dismiss filed in this case because there was a question as to whether or not the person is a director of the corporation. So yun yung administrative case that was ongoing at that time. Siyempre, as a defense of the plaintiff in the civil suit, sabi niya, I cannot say that is not a prejudicial question. Yung administrative case on the status of the person, whether or not he's a director of the corporation. So what did the Supreme Court say? On the contrary, it is a prejudicial question because determining whether or not the person is a director of the corporation shall have the effect of what? It shall have the effect of determining whether or not this suit for sum of money shall push through. So yun yung sabi ng Supreme Court. And in Alson's Development and Investment Corporation, a 2019 ruling of the Supreme Court, a civil case was determined as also prejudicial to another civil case, whereby, one suit here was determinative of whether or not another shall lead to the dismissal. So yan ang natin. Those are the important points that I want you to remember on the book of persons. So of course, we have to proceed to family code. And just a reminder for you to always remember itong ating essential and formal requisites of marriage. So we do not need to dwell on that for an extended period of time because these are things that you are supposed to know, as well as Article 4 on the effects of the absence or defect of any of the essential or formal requisites. So please just pay attention. These are not surefire to be asked, but you have to remember these at least. Pero I am confident that you should know this because why? Because during the time that these concepts were introduced to you on marriage, these were the times na excited pa tayo, kakapasok lang natin ng law school. So all of those first things that you read were involving marriage, di ba? So yung Articles 2, Article 3, and Article 4, those are the first lessons ingrained to our mind. So let's proceed now to void and voidable marriages. So what should we remember with void and voidable marriages? Another reminder to just know yung ating marriages that are void from the beginning. We have to take note na in case you cannot remember or you did not memorize what are the void and voidable marriages, just remember to always correlate this with Articles 2, 3, and 4. So in order for you to have a working knowledge of what are the void and voidable marriages. So remember that, kasi yung tandaan natin, yung legal capacity, consent freely given. If you're looking at the contract, basically, this is just wala nang object in cause, di ba? It's just consent pagdating sa marriage natin. So, everything that involves consent, that will lead to void and voidable marriages, di ba? And always remember, yung ating void by reason of public policy. Public policy, meaning to say, yung mga kadiri, pag-iisipin natin na marriages, stepbrother and stepsister. Basically, yung ating adoptive parent versus adoptive child. So yung mga ganong marriages ba, those are void marriages by reason of public policy. So just remember these, yun ang mga items that we have to remember. syempre, it's important for you also to remember Article 45 of the Family Code, whereby itong mga instances of voidable marriages, di ba? Yung mga voidable marriages natin, yung below 20, yung 18 to 21, ano pa ba? Yung unsound mind, yung ating consent obtained by fraud, yung ating consent obtained by fraud, intimidation, basically in relation to our voidable contracts, which we will discuss, I guess, in 1 hour. Yung sa ating obligations and contracts, you cross refer that yung voidable contracts with Articles 2, 3, and 4 of the Family Code, so that you will be able to remember. Kasi for me, it's important for you to have a deeper understanding of the law in order to avoid the pitfall of having to memorize. Kasi for me, if you memorize, there is a possibility that you forget it at the time that you need it most. Alam naman natin, may jurisprudence to that effect. But if you have a deeper understanding of the law, there is a possibility that you can come up with a reasonable enumeration, so to speak, just so that you will be able to come up with a fighting enumeration in your answers to the bar examinations. So yan ang ano natin. And of course, we cannot finish the topic on void and voidable marriages without going through Article 36 on psychological incapacity. Basically, ang pinakamalikot na provision sa Civil Code just because of the needs of a lot of people or a lot of married people, di ba? So we all know the revisions that it has gone through the years, di ba? Basically, what we have now is the definition provided by the case of Tan Andal. Alam naman natin yung history ng mga barristers with Tan Andal of last year. Basically, there was a shining light illuminated upon the case of Tan Andal that you must remember this. And unfortunately, it was misdirection, di ba? Justice Hernando did not ask anything about Tan Andal. So we just have to remember the definition of psychological incapacity as provided for in Tan Andal. It should refer to no less than a mental incapacity that causes a party to be truly incognitive of performing essential marital obligations. So, alam naman natin, essential marital obligations in reference to Article 68 to 71 of your Family Code. So, yun yung tanda natin. That is why, when we go to the guidelines or the parameters provided by Tan Andal, let us just, it is deeply related to Article 68 to 71 of the Family Code nowadays. It's no longer dependent on the findings of your clinical psychiatrist. Kasi dati, it's dependent on the clinical psychiatrist. Nowadays, when we talk about the clinical psychiatrist is even doubted. Why? Because usually, the clinical psychiatrist in several jurisprudence, since the advent of Tan Andal, the findings of the clinical psychiatrist has been doubted because the clinical psychiatrist only interviews one side of the problem, so to speak. Basically, the petitioner or the plaintiff in the suit for annulment of marriage is only the one being interviewed by the clinical psychiatrist. What's the effect? Sabi ng Supreme Court, that is self-serving. So you have to include several other witnesses in order for the courts, whether it be the lower court or all the way up to the Supreme Court, to believe that there is a defect on the part of the person, rendering him incapable of performing the essential marital obligation. So yun yung tanda natin lesson in Tan Andal. So let us enumerate yung requisites ng Tan Andal. It must be the burden is belonging to the plaintiff. So as always naman, it belongs to the plaintiff. Another requisite that erased number 2 involves that the incapacity is so enduring and persistent with respect to a specific partner. So remember that. What this means is that even though you are declared by the Supreme Court to be, or the lower courts without appeal, to be psychologically incapacitated to enter into marriage with your ex-wife, if the marriage has been declared null and void, sabi ng Supreme Court, it doesn't disqualify you from entering into another marriage with another person. So yun yung ibig sabihin ng Supreme Court dito sa second requisite. So another requisite is that it must be shown to be medically or clinically permanent or incurable. But always remember that it is only concerning the present partner or the present wife or husband of the plaintiff. So yun yung tandaan natin as to the third requisite. Another requisite is that it must be grave enough to bring about the disability to assume the essential obligations of marriage under Article 68 to 71 of your family code. And we all know what those are. And finally, as was utilized in the case of Romero, a 2022 ruling of the Supreme Court, if I'm not mistaken sa year, it may be 2021 or 2023. Pero yun na nga, that was the case of Romero. The interpretations given by the church, meaning to say, if the church declares your marriage as null and void, it can be binding. Well, not binding, wrong word. Binding is wrong, the wrong word. It could be used by the lower court or even by the Supreme Court as basis to declare your marriage as null and void. So finally, in Article 36, we just have to look at this 2022 and 2023 ruling of the Supreme Court, whereby yung classic example ng husband who beats up the partner, who does not support the partner, and who is pabigat to the family was declared null and void ab initio. Sabi ng Supreme Court, psychologically incapacitated in relation to one case decided by the Supreme Court. I was not able to cite it here, but in relation to one case decided by the Supreme Court, whereby even though there was a showing that the husband demonstrated these incapacities to perform the essential marital obligations, what was the problem? The problem, yung babae, in that case that I am talking about, ng lalaki. So, she had another partner, kaya what is the effect? The effect was not granted. So, kaya, what is the lesson in this case? The lesson, hintayin mo lang, the joke lang. Well, the lesson in this case, if you are a woman that is seeking annulment of your marriage with your husband, or a husband seeking annulment of your marriage with your wife, you just have to secure the declaration of psychological incapacity first before you enter into another relationship. So yun yung lesson doon, ano. Kasi yun nga important itong case na to, because it demonstrates to you that there is that it could now be a ground for declaration of nullity of the marriage, di ba? Yun yung tandaan natin dito. Kaya itong case ng Alberto and tong Asejo, remember these rulings of the Supreme Court. So moving forward to our family code, let's discuss the system of absolute community, or the property relations involving marriage. So when we talk about the system of absolute community, we all know how it goes. Co-ownership, and then all of the properties at the time of the marriage shall belong to both spouses, di ba? Kumbaga, kaya nga absolute community. That is why it is important for us to remember yung statement ng Article 92 as to those properties which are not included in the absolute community of property. Number one being those properties which are acquired by gratuitous title. Number two is those properties which are for the exclusive use of the person. To say jewelry, in the case of men, watches, di ba? Alam naman natin yan. And those which are acquired by a spouse or kumbaga, the other party or the spouse. What do we call ba yung ano? Kung spouse ba babae, kung sa lalaki husband, di ba? Anyway, that which has been acquired by the spouse or the husband in a previous marriage, di ba? That is excluded. Why? Because that has to be given to the children when the time comes na namatay na yung husband or the wife in that case. Kaya these are excluded in the enumeration of community property. And remember, another exclusion, yung damages recovered by spouse. So basically what the Supreme Court has been clear in ruling is that if the spouse, if it is foregone income, it belongs to the absolute community property. But if it is something that has been committed upon the spouse or the husband personally, meaning to say, well, whatever, di ba? Kumbaga, there's a crime committed against the husband or the wife, not by the husband or the wife, but meaning to say, there's a crime committed, and as a result, there are damages awarded, then that belongs exclusively to such husband or wife. This leads us to the conjugal partnership of gains. So when we talk about the conjugal partnership of gains, we all know how it goes also, hopefully, that the husband and wife pool their property and the profits that they earn shall belong to the conjugal partnership of gains. Remember this, remember the conjugal partnership of gains in relation to the system of absolute community. Kasi actually, I just had this sinking feeling that it could be asked. There could be a question later on in wills and succession whereby how will you divide the property if the marriage is governed by absolute community or conjugal partnership of gains. So yun yung that is a sinking feeling that I felt na para bang baka yung trick doon sa question is conjugal partnership yung magiging system of yung property relation between the husband and wife. So when the time comes na namatay ang either husband or wife, remember that when you talk about conjugal partnership of gains, what belongs to the CPG is only the profits or the income that may be earned by the conjugal partnership. So meaning to say, all of their contributions. Let's say that husband brings a condominium unit which earns rental into the conjugal partnership, while the wife brings forth a business that earns income. So what forms the conjugal partnership? Basically, the profits that are earned by the condominium and the business. So yung profit nun, yun yung mapupunta sa conjugal partnership, which shall then answer for the obligations of the husband and wife to the family. So yun. But when the time comes na namatay ang either husband or wife, remember that the property that is brought by the husband or the wife to the conjugal partnership shall pertain to him and him alone. Hindi yun mapupunta na sa husband or wife din yung kalahati nun, etc. Di ba kasi yun yung ruling natin, yun yung provision natin pagdating sa wills na yung wife entitled siya sa etc. Yung kumbaga, yun yung matatanda natin. But remember, yung conjugal partnership, babalik yun sa husband or sa wife, such that when the time comes, kukunin muna dapat ng wife or ng husband yung property niya, saka tayo magdedesisyon kung ano ang paghahati-hatian ng heirs on the property. So I just had the sinking feeling earlier. Basically, I am lecturing 9 o'clock, 8:30. I just felt that this could be a question kasi there was a portent of things to come with Justice Lopez na baka daw medyo yung nakakalito daw yung bar niya related to, kumbaga, Justice Lopez daw wants to be firm as to the bar examination. So yun lang naman. Anyway, when we talk about CPG, always remember also those which belong exclusively. So basically, those which are brought to the marriage by the husband or the wife, those which are acquired by gratuitous title, and those which are acquired by right of redemption. So remember those kasi these are the areas where possible questions can arise. Kasi it's important for you to note that there is the general rule on conjugal partnership of gains, and there are, of course, exceptions as to what constitutes property. So such that in continuation to these properties which are not or which do not take part of the form part of the conjugal partnership of gains, yung donated or left by will shall still belong accordingly to the spouse or the husband separately. So, but also remember our Article 123. Basically, if the husband or wife wins in gambling, it belongs to the CPG. But if they lose, bahala ka sa buhay mo. Di ba? Yan yung Article 123 of the Family Code. So, yan yung tandaan natin pagdating sa article sa absolute community and then sa CPG. And of course, before moving on, we have to remember what is the rule that shall govern on property regimes of unions without marriage. Basically, it's just a comparison of Article 147 and 148 of the Civil Code. We have to remember that in Article 147 involves an instance whereby there is no impediment to marry one another, but they just choose to live as common law husband and wife. In such a scenario, what is the rule in the event of the death of one of the spouses? So basically, hati silang dalawa. So yun yung tandaan natin. Even though in property regime of unions without marriage, the default property relation is that of co-ownership. The difference between Article 147 and 148 is that in 147, there is no need to prove what is your actual contribution to the common law partnership before you can be entitled to half of what your husband owns or your wife owns. But in Article 148, the proof of the actual contribution must be given by either the husband or the wife before their respective share or shares is or are determined accordingly. So yun yung tandaan natin pagdating sa Article 147 and 148. Yan lang yun. Malaki sa akin. Kahaba-habang provision na yan. Yun lang ang tandaan natin pagdating dyan. The family. Why is it that the family is included here? Because we have to remember Carlos Yulo right now. Di ba? We all know how the bar examination tends to straddle towards current events in the questions, di ba? And it is I cannot say 100% pero for sure may tatanong dito kay Carlos Yulo na to. And we have to remember, di ba? Family. So I just highlighted Article 151. So we all know that Carlos Yulo and his mom and Carlos Yulo respectively are obliged to support one another, diba? We all know that. But we just have to remember Article 151 in relation to that na before suit may be lodged by one against the other, there must be an earnest effort to come to a compromise before such suit may be lodged. So that's the one thing that's my prediction on Carlos Yulo. At least in regarding civil law, there have been a lot of speculation na baka sa taxation law maglabas din si Justice Lopez. Definitely. Sa dami ng mga napanalunan ni Carlos Yulo, definitely magtatanong sa taxation yan. Another item that we have to remember involves the family home. So the reason why yung family home is included in my is because we have to always look. Just a tip for you students who are looking to predict for yourselves areas that you want to focus on in your studies. Just look at conflict points in the provisions of the law when you are looking at areas. to focus on the last minute before you take the bar examinations. And the family home is one of them. So we all know how the family home is, di ba? The family home is the home where the family lives. So basically, as long as it is constituted as a family home, how is it constituted? Basically, the family has to live there and the family has to own that home. But that's not the conflict that we have to remember here. The family home, of course, is subject to a lot of instances whereby a suit is lodged against either the father or the mother, and as a result, an execution of the family home is sought. So, what can we say about the suit for the family home? So, we have to remember Article 155. Family home shall be exempt from execution for sale or attachment except for non-payment of taxes, lifeblood. We have to remember that. For debts incurred prior to the constitution of the family home. So prior to the constitution, meaning to say, if your family home was built year 2000 or acquired year 2000, that's acquired. So basically, if you took out a loan from the bank in order to acquire your house, that is such that that has been incurred prior to the constitution of the family home. How about paragraph 3? For debt secured by mortgages, so basically, yun yung natin, before or after such constitution. So basically, when we say after such constitution, if you took out a loan, let's say you took out a business loan and you mortgaged your home, as a result, that is an instance whereby the family home can be subject of execution or forced sale or attachment. And then for debts due to laborers, mechanics, etc., and those who have been responsible for building your family home. So basically, you did not pay your contractor and your contractor filed suit against you. This is the basis for such family home. We have to remember also, for your family home, the requirements for exemption. So as has been outlined as recently as 2022, these are the requirements for the exemption from your family home from execution. So remember what we said earlier, except syempre under Article 155, pero for the family home to be exempt from execution, it must be lived on by the family, must be constituted on land belonging to the family. Okay? And the value of 300,000 pesos in the city or 200,000 pesos in the province or in rural areas, so to speak. How do you reconcile this provision? So basically, how do you reconcile 300,000? So basically, it's important that we take note of the fact that it is that 300,000 peso homes are no longer possible nowadays, di ba? So the reckoning point of family home should be the time that it is built. So basically, it's a reason why there should be, to my mind, there should be an amendment of the family code to reflect basically current prices. So siguro dapat at least 1 million pesos, di ba? 1 million pesos and let's say 750,000 for rural areas, di ba? So dapat meron tayong amendment now to reflect yung of the family code to reflect the current prices of property, di ba? So we all know how it goes. So if the value of the family home exceeds such amount of 300 or 200,000 pesos at the time of its acquisition or at the time that it is built, then the 300,000 or 200,000, yun lang mababalik sa'yo as the owner of the family home once it is sold off. So yun yung tanda natin. Paternity and filiation. So basically, this is our last topic in persons and family relations. Paternity and filiation, we have to remember how it goes. So the general rule that we have to remember is that all children shall be considered legitimate for so long as they are born within the marriage. So meaning to say, class, kahit pa ang wife ng lalaki For so long as the child is born during the time of the marriage between the husband and the wife, that child is presumed to be legitimate. Henceforth, there can be only the following grounds to assail the legitimacy of to impugn the legitimacy of the child. So under Article 166, basically we have to remember just remember the following. For so long as it can be proven by the husband that it is physically impossible for the husband to have sexual relations with his wife before basically for 9 months reckoning. Have to remember 9 months reckoning yan. Yun yung only instance whereby there could be a means to impugn the legitimacy. So yun na nga. The enumerations that you could see in Article 166 all point out to the said scenario. That is the only one responsible. Physically impossible except for artificial insemination, di ba? Except for artificial insemination. Remember that it is only the husband who can impugn the legitimacy of the child. Can the wife impugn the legitimacy of the child? The wife, remember, cannot impugn the legitimacy of the child. Why? Because sabi nga ng Supreme Court in one recent ruling, it is how can you impugn as the wife the legitimacy of a child born to you? O, di ba? Hindi pwedeng mangyari yun. The wife impugns the legitimacy of the child. But it is only the husband, and in exceptional scenarios, the heirs who can impugn the legitimacy of the child. So we all know when the heirs can impugn the legitimacy of the child. So basically, if the husband dies before the period has expired to impugn the legitimacy of the child, it's only then that the children can impugn such legitimacy of the child. So yung heirs, yun lang ang period that is allowed for them. Kasi nga, why? Because this will affect their respective legitims. Kaya they're given the time to impugn the legitimacy. But if these respective periods provided for by the law are passed, then there can be no more impugning of the legitimacy of the child because of this rule. The children conceived or born during the marriage of the parents are legitimate. Remember that general rule. So that is why those are the rules for impugning the legitimacy of the child. So now let's proceed to Book 2 of the Civil Code on property ownership and its modifications. So, of course, we have to start with the enumeration of immovable property. Article 415 is clear on what are considered immovable properties. So basically, when we talk about immovable properties, these are properties that are obviously immovable, meaning to say lands, buildings, which are adhered to the soil, diba? Kasi these are immovable. And most importantly, those properties which seem to be movable but are considered by law to be immovable. So it's important for you to have at least a grasp of what are these properties which seem to be movable but are actually considered by law to be immovable. One of these are involved machineries. So basically, when we talk about machineries, we should have the impression that it is movable. But if these machineries are used for the business and these are placed therein by the owner of the land, we have it shall be considered as immovable accordingly by the law. And here we could see the requisites for machineries to be considered as immovable. As mentioned, when we go back to Article 415, there are, of course, several cases that we could use to discuss these principles. But I'm assuming that you all know them already. Just remember that when we talk about Article 415, there are two kinds of immovables, the obvious ones and those which are not obviously immovable, but are considered immovable just because the law classifies and considers them to be such. So remember or pay attention to the requisites accordingly. Next up on our discussion on property, involve property in relation to the person to whom it belongs. So when we talk about property in relation to the person to whom it belongs, we of course refer to those properties of public dominion, patrimonial property, and property of private ownership. So we all know properties of public dominion to be those properties which are either devoted to a public use, public service, or for the development of the national wealth. So when properties are considered property of public dominion, they are considered inalienable, as we are supposed to be, or as I hope you are well familiar with. Once these properties are no longer needed for public use, public service, or for the development of the national wealth, then they shall become patrimonial property, or properties which the state may utilize for their own capacity or for a proprietary purpose. Question: is there a distinction between patrimonial property and property of private ownership? The answer is there is none. When you talk about property of private ownership, the state utilizes patrimonial property for proprietary purposes similar to owning property privately. So whenever you talk about property which is privately owned, whereby, as we will discuss shortly, it is covered by all of the effects of acquiring property, meaning to say ownership, co-ownership, accession, possession, etc. These are possession, or these are devoting these properties to private ownership, or these are the attributes of property of private ownership. When a property becomes patrimonial in nature, the state has the right to devote property to private ownership accordingly, and thereafter consider it as being susceptible to all of those attributes of private ownership of property. Henceforth, there is no distinction between property of private ownership and patrimonial property. So another shining light that we could remember from the 2023 bar examinations is the case of Pasig-Rizal Company Incorporated. So this is another shining light which was also not asked in the bar examinations. Why was it not asked in the last bar examinations? We don't know. Basically, another misdirection of our esteemed Justice Hernando. But for purposes of property in relation to the person to whom it belongs, when it has relation to the distinction between properties of public dominion and patrimonial property. Why does your case of Republic versus Pasig Rizal come into the picture in this scenario? Because we have to remember that the former scenario involving patrimonial property is that before property of public dominion can become patrimonial property, it must undergo a series of acts coming from either Congress or the President before it can be considered patrimonial property in nature. What am I talking about? Number one, it must be released from being property of public dominion, meaning to say, it is no longer devoted to a public use, public service, or for the development of the national wealth. There must be an express congressional fiat to this effect. And number two, after having been declared as such, as no longer being needed, there must also be a declaration that it is susceptible of use by the state for patrimonial purposes or proprietary purposes, proprietary purposes. So kailangan dalawa ang act that will come from Congress before property can be considered as before property of public dominion can be considered as patrimonial property. Because of the case of Republic versus Pasig Rizal, the Supreme Court now only requires that property must be declared as alienable and disposable before it can be considered as patrimonial property. What do I mean to say? What does the Supreme Court mean to say? The Supreme Court, first of all, equates property of public dominion to the lands of public domain. So, when you talk about lands of the public domain, sabi ng Supreme Court, there is no distinction between lands of the public domain and properties of public dominion. As we have well learned from our lessons in land titles and deeds, when we talk about lands of the public domain, before it can be considered as susceptible of private ownership, it must be declared as alienable and disposable. So, yun yung requirement of land of the public domain. How does that relate to our property, to our patrimonial property? Yung ating lands of the public domain being declared alienable and disposable. The Supreme Court said, because there is no distinction between lands of the public domain and property of public dominion, once lands of the public domain are declared to be alienable and disposable, it is now equivalent to property being declared patrimonial in nature. So what do we mean to say? According to the Supreme Court, if property is idle land, meaning to say, it was not devoted to a particular public use before it was declared alienable and disposable, once it is declared alienable and disposable, it is now susceptible to being considered patrimonial property. And what is the effect if property is considered patrimonial? It may be susceptible to the modes of acquisition of ownership under the Civil Code. Because we have to remember that when you talk about lands, when you talk about patrimonial property, these are the only kinds of properties which are susceptible to the modes of acquiring ownership under your Civil Code. Hence, if it is not, if it's not patrimonial, no such acquisition. As a result, you cannot acquire land by prescription, or you cannot acquire it by donation if it is not patrimonial in nature. So yun yung effect nun. However, and this is what I think is probably going to come out in the bar examination if ever there is a question on Republic versus Pasig Rizal, we have to remember also the case of Laurel versus Garcia. So ano ba yung nangyari sa Laurel versus Garcia? Remember the Roppongi properties, di ba? Yung Roppongi property, there was a question as to whether or not it can be sold. So sabi ng Supreme Court, cannot be sold. Why? Because there was a failure to expressly declare this property as, number one, no longer being needed for public use, public service, or for the development of the national wealth. And number two, being released as such into patrimonial property or being considered as patrimonial property. So, if there is no such release, according to the Supreme Court, it cannot be sold, these Roppongi properties. So, how does that relate to our case of Republic versus Pasig Rizal? This case of Laurel versus Garcia still has an effect to this date. So according to the Supreme Court in the case of Republic versus Pasig Rizal, if property is previously devoted to a particular public use, public service, or for the development of the national wealth, there must be an express declaration that the property is patrimonial in nature before it can be considered as being patrimonial or being considered as patrimonial as such. So yun yung sabi ng Supreme Court. I hope you appreciate the distinction between the two. Whereas if property is not previously being devoted to a particular public use, mere declaration of the land as alienable and disposable is equivalent to it being considered patrimonial. But if the property was previously devoted to a particular public use, it shall be there needs to be an act declaring it as patrimonial before it can be susceptible of being considered as patrimonial in nature. So yun yung yun yung masasabi natin sa case ng Republic versus Pasig Rizal before yun yung two possible questions that we could see in the case of Republic versus Pasig Rizal. Ako yun ang masasabi ko sa inyo. So next for our discussion is the question on how property is acquired, or basically the modes of acquiring ownership. We have to realize that there's no need to discuss our numbers 1, 2, and 3 because these are because of the limitations of time. But we have to discuss yung number 4 on donation, because yung donation natin, ito yung masasabi natin na there are questions coming from this topic through the years. So we all know donation as an act of liberality whereby a person disposes gratuitously of a thing or right belonging to another. So what is the primordial topic that we have to remember with donation? So double donation muna. Ako yung gusto kong i-discuss sa inyo, double donation. So when we talk about double donation, there is a Supreme Court ruling that there is a provision to the effect that when you talk about double donations, you refer to the provisions on double sales to determine the rights that are available in instances of double donation. Is this the case that when you talk about Article 744, you also refer to Article 1544 on double sales for purposes of determination of what are the rights of a double donee in this scenario? The answer is no. The Supreme Court, through an opinion of Justice Vito, has said that when you talk about double donation, the second donation is no longer valid. Sabi ni Justice Vito, because it is a requirement of donation that the person donating the property must be the owner thereof. Once there has been a first donation that has taken place, there can no longer be a second donation that can take place. So as opposed to our rules on double sales under Article 1544 of the Civil Code, yun yung effect ng double donation. The second donation is no longer valid. So yun yung tandaan natin pagdating sa double donation. So in relation to donation, let us also remember the kinds of donation. So when we talk about the kinds of donation, syempre nandyan tayo sa simple, remuneratory. We also have your conditional. So yung conditional kasi ito yung kadalasan na nagiging questions sa bar examinations. So the classic conditional donations can be seen in this 2005 case of CJ Yulo and Sons, whereby there's a condition of putting up a structure, basically a hospital, in the donated property before there can be for the validity of the donation. In this case of CJ Yulo and Sons, what happened? There was a sublease of a portion of the property that was made by the donee. Hence, the donor, si J. Yulo and Sons, filed suit for the revocation of the donation by reason of the violation of the condition of putting up a hospital. What happened? Supreme Court ruled that this is not a violation of the condition for the donation. Why is this the case? Because there was no sale of the property. There was just a sublease. So sabi, there was no violation of the condition. There was still a hospital being put up on the property. If there was a sublease, it is only incidental, and this did not result in the sale of the property. Hence, there's no violation of the condition. So in terms of the kinds of donation, we also have to remember, let's look for ito muna. Republic versus Silim. I don't know why I put this here, pero kumbaga, this should be put in the conditional donations portion. Republic versus Silim is one of my favorite cases in donation, because in the case of Republic versus Silim, there was an exchange of the property that was made by the donee. Basically, what happened in this case, property was donated to a local government unit in Zamboanga. So, a family donated property to Zamboanga, and then thereafter, what happened? When they were about to put up a school on the property, there was a prohibition to do so. Sabi kasi ng Department of Education then, you have to put up a school on property that is at least certain land area. So let's assume 1 hectare of land. So what happened? Mayor of the said LGU in Zamboanga came up with a genius solution. Sabi ng mayor ng LGU, swap na lang natin yung property ko doon sa property na yan. Okay. So the donors of the property later on, so that instead of the school being constructed, the house of the mayor was being constructed on their donated property. So of course, they filed suit for the revocation of the donation. What happened? Supreme Court said that there was no violation of the condition for the donation. Anong sabi ng Supreme Court? There was no violation of the condition because when the swap of the properties took place, there was still a fulfillment of the condition of the donation, which is to put up a school. So when there was still putting up of the school on the donated property, no violation of the condition resulted. So yun yung basically na matanda natin pagdating sa condition. That's why one of my favorite cases, syempre, during the regular review, I could elaborate on this further, pero not with our time limits and not with your time restrictions also in studying. So anyway, yan yung case ng Republic versus Silim. So moving on to the kinds of donations, we also have of course yung ating donations inter vivos and mortis causa. It's important for you to know the distinctions between a donation inter vivos and mortis causa. So when we talk about a donation inter vivos and mortis causa, one word must be remembered for you to have a clear distinction between the two. It's irrevocability. So when we talk about a donation inter vivos, it is irrevocable. So basically, it takes effect at the time of the donation. What is the reason why there is confusion between inter vivos and mortis causa donations? There can be confusion because there are instances whereby a donation inter vivos is stylized as being mortis causa, meaning to say, you will have possession of the property upon the death of the donor. So, napapagkamalan siya na mortis causa in such a scenario. Kasi nga, halimbawa, yung donation, sasabihin niya, you will have possession of the property after I die. Pero this will take effect right now. The donation will take effect right now. So, in this scenario of inter vivos, property shall remain with the donor, fruits shall remain with the donor. Basically, usufruct shall remain with the donor. How is that a donation inter vivos in such a scenario? It is a donation inter vivos because if the donee dies before the donor, what will happen? to whom shall the property pass? Shall the property pass to the donor, or shall the property pass to the heirs of the donee? Under your civil code and under jurisprudence, consistently, there has been a ruling that once the donee dies, property shall pass to his heirs instead of reverting back to the donor. That is the characteristic of irrevocability of the donation inter vivos as compared to a donation mortis causa, whereby in a donation mortis causa, if the property is retained by the donor during his lifetime, basically in compliance with the requirements of the civil code on the form of wills, what will happen if the donee predeceases the donor? The donor shall retain possession of the property. So it shall not go to the heirs of the donee. Yun yung difference ng mortis causa sa inter vivos. Kaya lang nagkakaroon ng lituhan dito sa concepts na to because yung donor kadalasan in these scenarios want to retain the property while they are alive. But yun na nga, yun yung distinction between the two concepts. So just remember that, pay attention to that term irrevocability when we are talking about a donation mortis causa and inter vivos. So syempre, there are, as you could see with my slide, there are certain concepts that we have to remember. But in order for you to not be confused, just remember the word irrevocability for purposes of your donation inter vivos and mortis causa. Yun yung ano natin. Yun yung tip ko lang sa inyo. Okay, so with donation also, we have to remember another important portion, which is revocation of the donation. So what can we say about revocation of the donation? When we talk about revocation of the donation, of course, it is an instance whereby there is a reversion, or the property shall revert back to the donor because of violation of conditions, or because there is a supervening event that takes place that results in the revocation for just cause of a donation. So there are, of course, few instances for revocation of the donation. Basically, if there is an ingratitude committed by the donee against the donor, if there is an heir that all of a sudden appears, which affects the legitim, there can be a revocation of the donation. And also, if there is a violation of the condition of the donation, what can happen? There can be a revocation of the donation. As you could see in the slide, the periods for the revocation of the donation follow, diba? 4 years, and at any time during the lifetime of the donor. Let's just proceed to this one, yung ating Republic Clemente versus Republic, a 2019 ruling of the Supreme Court. This is a case that actually came out in the 2022 bar examinations, the Kagiwa bar examinations. What happened in this case of Clemente? Basically, 41 years public hospital was not put up. So, of course, the donors wanted to revoke the donation. Anong sabi ng Republic dito, ng DPWH? Sabi nila, there's no need to revoke the donation because we are still putting up the hospital. Supreme Court ruled that revocation is in order. What was the complication that took place? The complication that took place is that if we look at the prescriptive periods to file revocation, how long should it take? It should take 4 years only. Diba? Yun yung sabi ng Supreme Court in its rulings, and also by the Civil Code. It should take 4 years only. So basically, from the time of the violation of the condition, 4 years lang. You can revoke the donation thereafter. But if it exceeds the 4-year period, then you can no longer file suit for revocation. So of course, yan yung complication natin. What is the problem? The next question now is, when is the reckoning period to determine that there has been a violation of the condition for the donation? Yun yung tandaan natin na nagiging complication dito. Why? Because there can be scenarios that this complication does not arise. Number one, there will be no complication if the donor states the period within which the hospital or whatever structure he wants to be built on the property shall be finished. So meaning to say, if the donor says, dapat matapos mo within 5 years yung hospital, otherwise the property reverts back to me, no complication there, di ba? But the problem is, if the donor does not state the period over which the public hospital shall be built, then magkakaroon tayo ng problema doon. So kailan tayo ngayon magkakaroon ng reckoning period to determine when shall there be a revocation of the donation? The answer given by the Supreme Court is simple. Number one, if there has been no period for revocation, then you can go to the court and ask under Article 1197 to fix the period within which the revocation of the donation can take place. So basically, halimbawa, after 10 years, hindi pa rin tapos si hospital, pwede kang pumunta sa courts and then ask the court to fix the period for the revocation of the donation. So pwede sabihin ng court, if within 4 years you are not able to put up the hospital, then donation is revoked. Okay, one scenario. But what if, in this case, it took 41 years for the hospital to not be put up? Has there already been a prescription of the donation? Supreme Court said prescription in terms of filing suit for the revocation of the donation. Supreme Court said no. There is still no prescription because once this interim period has lapsed, then the court can basically the court can say that the donation shall be considered revoked. So meaning to say, hindi pwede mangyari yung gusto nito ni ng Republic, that there is a prescription already to file suit to revoke the donation just because of your failure to put up the hospital in the first place. So sabi ng Supreme Court, these are the scenarios that will take place. So that honestly was asked 2 years ago. I have a feeling it can be asked in this bar examination. So yun yung natin. Kasi it's a complicated issue. Sabi ko naman sa inyo, when you look for areas to finalize in your studies, just look for conflict points in order to come up with them. Okay, so let's move to prescription. So just remember that only in instances whereby possession is in the concept of an owner can prescription take place to benefit a person, for example, a landowner. That's why it's important to remember the 2003 case of Bogo Medellin. Ano ba yung nangyari dito sa case ng Bogo Medellin na to? Yung railroad tracks that were based on an easement. So basically, the Supreme Court said that easement, by definition, is just a permission given to you to use the property by the actual owner of the same. Hence, when you possess it, it is not in the concept of an owner, but in that of another. In relation to prescription, once again, let us go to the case of Pasig Rizal Company Incorporated. So what can we relate the case of Pasig Rizal Company Incorporated to the concept of prescription? We have to remember, in the case of Pasig Rizal Company Incorporated, there was now a question. Is it still 30 years yung ating period to reckon for purposes of determination of acquisition of property? The answer, Supreme Court said, relating to 11573 or Republic Act number 11573, it is no longer 30 years now. For purposes of determining yung ating prescription, it is now 20 years. So simply put, because of 11573, it's now 20 years. It's no longer 30 years. It's as simple as that. And I don't think this will come out in the bar examinations kasi sobrang simple, 20 years, di ba? So wala itong ano natin. Another matter that we have to remember with prescription has to do with the effect of its laws as against movables. So this leads to confusion sa totoo lang, yung prescription regarding movables, because we have to remember that if a person acquires a movable with no definite with no clear ownership, meaning to say you find something, a movable, and no clear ownership of the same, you acquire it in good faith or without need of good faith, it's 4 or 8 years respectively, di ba? For purposes of prescription, when the property shall be considered yours. However, what if the owner, after 5 years in good faith, after 9 years otherwise, comes to you and says, akin na yung property ko, akin na yung movable ko. My favorite example, let's say a pair of Jordan 11s that you do not know who the owner is. You took it. It's on the side of the street. You took it and then you say, oh, akin na tong Jordan 11 na to. So after 4 years, you say it's yours, or after 8 years accordingly. 5 years or 9 years later, owner comes, akin na yung Jordan 11 ko. Can the owner recover the property? The answer is yes. The owner can always recover the property, the movables that have been lost or taken from him. As we could see from the clear provisions of Article 559 and Article 1505 of the Civil Code, the owner of a movable cannot lose it. Kumbaga, there can be no prescription that runs as against the owner of a movable. For so long as what? For so long as if the owner of a movable, if the current possessor of property acquires it in a good faith sale of the same, then the owner or the real owner of the property must pay for what the current possessor of the property acquired it for. So let's say, yung Jordan 11 na yun, binili niya dun sa isang tao for 5,000 pesos, then you have to pay 5,000 pesos in order to recover such property. You cannot just take it from the current possessor of the same, because there is a presumption under the Civil Code that the current possessor of the same possesses it in good faith. So that is your prescription. So in relation to that, let's proceed to the third portion of our discussion. Kasi the first portion of our discussion is the enumeration of immovable property. We did not tackle movable anymore. I do not think that's important for purposes of our bar exams. The second portion of our discussion is basically the modes of acquiring ownership. The third portion of our discussion of property is the effect of acquisition of property. When I say the effect of acquisition of property, this is what happens when you are able to acquire property. And as we are well aware of, maraming effects ito. Yung ownership, co-ownership, yung ating accretion, ating possession, usufruct, and then yung ating easement. Finally, a fourth portion, yung nuisance. So let's discuss first yung ownership. Remember for purposes of ownership, the discussion on the attributes of the same. So as you could see here, these are the attributes that are important for you to just note na. You do not need to memorize this. There will be no bar question that asks you point blank, what are the attributes of ownership? Walang ganun. It's just important for you to know the attributes of ownership. Just remember this. Ito also asked in the 2022, sorry. Also asked in the 2022 bar examinations, itong artificial lake na case natin, the Spouses Andamo 1990 ruling. Basically, ano nangyari dito? There was a man-made lake that was built by a neighboring property which had an effect of spillover to to another property, or if we are going to call it via easement, yung ating dominant estate and yung ating servient estate. So basically, water was spilling over to the servient estate. So ang sabi ng Supreme Court, yung right to use in this case of spouses and damo, of course, is limited to what? Limited to for so long as you are not injuring another in the use of your property. This is a common example. I remember nun yung aking professor na si Atty. Arcilia. Sabi niya pinatayo niya ako nun, sabi niya, sing a song. Okay, sabi niya, do you sing, okay, so kumanta ako. Do you sing in the bathroom? Sabi ko, yes, sir. Okay, can you sing in the library? Yes, sir. Is that within your rights to sing in the bathroom and by yourself? Yes. But is it within your rights to sing in the library? Sabi, syempre, as we learned, no, it's not within your rights to sing in the library. Why? Because it is already injurious to the rights of others who want to study. Diba? So yun yung ibig sabihin nun. Similarly, in this case of spouses and damo, yun yung matatandaan natin. It is you can only use the property within your rights. So that's the restriction of your right to use. Another discussion that we have to make is the doctrine of self-help involving the right to use. So let's forward to a discussion of of number 4 case here, yung People versus Narvaez, yung homicide committed. Basically, property dispute. There was a homicide. Basically, one person shot another. When the accused was asked, why did you shoot the victim? Sabi ng accused, I was merely exercising my right to defend my property. There was a reasonable necessity to repel or prevent the invasion of my property. What did the Supreme Court say? That is not correct. So the self-help cannot be used to justify a crime that is committed. So always remember that. Yun yung limit ng ating doctrine of self-help, which is somehow ridiculous, di ba? Kasi, not the Supreme Court ruling, but the concept itself. Kasi if you think about that, if you think about the concept itself, na halimbawa na naglalakad ka sa Manila, tapos biglang dinukutan ka, hinabol mo yung snatcher. What is the extent that you can do according to the doctrine of self-help? Pwede mo siyang sigawan, hoy, balik mo sa akin yung cellphone ko. Pwede mo ba siyang bugbugin para ibalik yung cellphone? Hindi, di ba? Kasi you cannot commit a crime in order to recover your property. Once he has gotten away from you, what you can do now is just file suit against him, di ba? Theft, di ba? Yun yung masasabi natin sa doctrine of self-help niyan. Until such time that there's a new jurisprudence or amendment to this law, this is the extent of the doctrine of self-help. You have to remember this, yung state of necessity natin. Another attribute of ownership that we have to remember is the right to recover. So when we talk about the right to recover, always remember it as its relation to the reivindicatory actions. So we are well aware of what are the reivindicatory actions that are available, di ba? Yung basically yung ating interdictal, publiciana, and then reivindicatoria. Always remember that if somebody is in possession of property, whether it is movable or immovable, there has to be a suit filed in order to recover such property. You cannot take the law into your own hands. You cannot point a gun at a person and say, leave my property, even though this same person pointed a gun at you and told you to leave your property. So, syempre, you could sue the person, di ba? For taking your property criminally, but you cannot do the same to that person. So, yun yung tandaan natin. Kaya nga, meron tayong 3 suits available. syempre this is premised on the condition that what? That there's no extrajudicial means that have been agreed upon by the parties for you to recover your property. So yun yung tandaan natin pagdating sa right to recover. Let us now proceed to the second attribute of ownership. To the second effect of acquisition of property, which is co-ownership. What we have to remember with co-ownership is limited also to the following concepts. Number one, in the 2022 ruling of Marquez, anong sabi ng Supreme Court through Justice Hernando? Sabi ni Justice Hernando in this case, if there is an agreement between co-owners, even though the property has not yet been subdivided formally, meaning to say there has yet been any survey of the property, relocation survey, and then it is filed before the Register of Deeds in order for several titles to come out of the mother title, there is still a termination of the co-ownership already. So yun yung tandaan natin. So just an agreement between the parties terminates the co-ownership. Why is this the case? Because we have to remember that the Supreme Court abhors co-ownership. Ayaw ng Supreme Court, ayaw ng Civil Code ng co-ownership. Kaya any agreement to this effect which terminates the co-ownership shall result in its termination, whether or not as regards to titles involving land, it is already reflected therein. So yun yung tandaan natin. In relation to co-ownership, also remember yung partition of the thing owned in common. So there are restrictions to partition. Basically, if it is provided for by it can be agreed upon by the parties that partition shall only take place after 10 years. So pwede silang mag-agree to that effect. But if they agree for more than such 10-year period, hindi na pwede yun. That's already an express violation of the law. What if the property was donated or it was inherited by the co-owners of the property? The effect is there can be a 20-year period that may be placed for purposes of determining when the property can be partitioned between the parties. But also, we have to remember regarding your co-ownership that there can be an agreement anytime to partition the properties. So yun yung tandaan natin pagdating sa partition ng property regarding co-ownership. But also, never forget yung ating 1, 2, 3, 4, 5. Yung paragraph 5 ng ating partition ng co-ownership. Prescription shall not run unless there has been knowledge of the other co-owners. This is relevant in instances whereby another co-owner abrogates for himself the properties that are co-owned, presumably. So, meaning to say, if there's a property, 1,000 square meters, co-owned by 3 siblings, and one of them executes an agreement, or not an agreement, let's say an affidavit stating that he is now the owner of the property, it shall not have a binding effect on the other co-owners. Because why? Under paragraph 5, no prescription shall run in favor of co-owner unless there is knowledge of the co-owners. Okay? So yun yung tandaan natin. Pagdating sa Article 494 of your Civil Code. Let us just kumbaga, that is yung dapat natin tandaan pagdating sa co-ownership. Regarding possession, I have already mentioned this. Yung recovery of possession is only allowed if there is an agreement, if there's an agreement by the parties, or there is a suit filed accordingly. So, as I mentioned earlier also, yung good faith possessor versus the owner. Meaning to say, as I said earlier, even if a possessor of the property acquires it in good faith from somebody else, the owner can always swoop in and recover such movable. How does it affect immovables? It greatly affects immovables. Why? Because of the so-called mirror principle. What do we mean to say? When we talk about the mirror principle, if somebody acquires property that has been taken via void pretenses, meaning to say there is a title has been stolen from the real owner of the property, and this title was thereafter sold once to the one who took the property, and then sold a second time to an innocent purchaser for value. What is the effect of the same? Will the good faith possessor versus the owner of the property still have an effect? Meaning to say, will the good faith possessor always be susceptible of recovery coming from the owner of the property? The answer, in immovable properties, for so long as the good faith possessor is an innocent purchaser for value, it cannot be recovered by the owner anymore. Yun yung ating mirror principle, so to speak. So another effect of acquisition of property is yung ating right of accession. In the right of accession, just remember yung ating rules regarding good faith and bad faith. So when we talk about good faith, always remember the rights that have been given, or the options that are given to the owner of the land over which property there has been building, planting, or sowing. So basically, if the owner of the land is a victim of any building, planting, or sowing on property, but the building, planting, or sowing by another was conducted in good faith, what is the effect? The effect is that the owner shall have the right to choose between the options that are given by the law. Diba? Alam naman natin yun sa Article 448. Basically, has the option to purchase the property, has the option to tell the building, planting, or sower to pay the land, to buy the land from me, except if the land is much more expensive than the building, planting, or sowing. My favorite example, as always, let's say property was built, there was a building of a house on land which is located in, let's say, Ayala, Alabang. So let's say the house cost 10 million pesos to build. Syempre, this 10 million pesos is dwarfed in comparison by the value of the land in Ayala, Alabang. So basically, cannot compel the builder to buy the land because the land is too expensive, di ba? You can just compel the builder to pay rent accordingly. But what is the effect if the builder is a builder in bad faith? If the builder is a builder in bad faith, it is clear that what? It is clear under Article 449 that that he who builds, plants, or sows on land of another loses what is built, plant, or sown on the land of another. So he loses everything. Can also be compelled by the owner of the land to purchase the land. Kahit sabihin natin dun sa example earlier, Ayala, Alabang land, bilhin mo yung lupa ko. Ayoko yung bahay mo, pero kaya bilhin mo yung lupa ko para mangyari, makaalis na ako dito. Yun ang options na, with damages always. So yun yung tandaan natin pagdating sa accession. So as to another effect of acquisition of property, we also have easement. So when we talk about easement, what should we remember? So for easement, it's an encumbrance imposed upon an immovable. So always remember, it just involves an immovable. It's never an encumbrance on a movable. what you should remember for in order to have a chance to answer easement, kasi sa totoo lang, unless the easement question involves yung right of way, unless the easement question involves light and view na distance requirement as was asked to bar examination questions ago and right of way last year, you have to remember the kinds of easements. So basically, we all know kinds of easements to be positive, negative, apparent, non-apparent, continuous, and discontinuous. So just remember these kinds of easements. Kasi kapag halimbawa, medyo malikot yung isip ng examiner ninyo, whether si Justice Lopez or kung sino man ang examiner ng civil, baka dito kayo pahirapan sa easement. So, yung basics natin, remember the kinds of easement. So, remember the kinds of easement kasi in relation, halimbawa, doon sa sinabi ko sa inyo na tinanong 2-bar examinations ago, yung case ng Spouses Fernandez, there's a question as to whether or not there has already been an acquisition of the easement. So, it's not a distance question. Kasi yung easement of light and view, madali lang eh. Ano ba yung easement of light and view? Basically, you have to build 2 meters basically from the party wall, not from the distance of the house to the other. So, 2 meters, 2 meters, 2 meters, front, back, and then to the sides. Hindi yun ang tanong sa Spouses Fernandez and 2-bar examinations ago. Ang tanong, whether or not the construction of the house beside an open lot in violation of the 2-meter easement or distance rule resulted in the right of the dominant owner. Kasi dominant owner dito yung person whose property was affected whose light and view was affected by the builder of the house violative of the 2-meter easement rule. Sabi ng Supreme Court, in this case of Spouses Fernandez, is there was an easement already acquired by the owner of the dominant estate. Question, sabi ng owner ng servient estate, how come there was an easement acquired? If you look at the different kinds of easements, it can be classified as negative. Kasi it's a prohibition eh, di ba? Ang easement natin na negative, it's a prohibition to build something, like in light and view. Sabi ng Supreme Court, it is your fault to the servient estate. It is your fault that you did not comply with the distance requirements imposed by the Civil Code. So sabi ng Supreme Court, even though there is no formal prohibition that has been made by the owner of the dominant estate against you, the fact is, you did not comply with the distance requirements of the law. Henceforth, there was already an acquisition of the easement by virtue of its negative nature, whereby you are prohibited from building within such distance requirements. So that is the reason why it's important for you to know yung basics regarding easement, yung ating different kinds of easements. We also have to remember the concept of how easements are acquired. So basically, there are 2, legal and voluntary easements. So when you talk about legal, dito na papasok yung madali lang. What do I mean madali lang? When you talk about easement of right of way, dito pumapasok yun. So we all know how easement of right of way goes. So basically, ang easement of right of way, it's just when you are landlocked inside your property and you have no way to the public highway, you can demand for a right of way through another estate. So you, as the dominant estate, can demand from a servient estate that they give you access to the public highway. So we all know the rules of 649. So just pay attention to them. And madali lang naman yan, yung 649 na yan. Just imagine a scenario that you are landlocked and you need a way to the public highway, di ba? Yun lang naman yun. Siyempre, you have to pay just compensation for the property that has been given to you, di ba? So yun yung tanda natin. As I mentioned, unless the question on easement of light and view involves its acquisition, madali lang din tong light and view. It's just a determination that there has been a failure to comply with the 2-meter requirement starting from the party wall, not from the building itself, not from the house. It's party wall. That's actually a real question in my mind always, kasi we see in the Philippines that there's a constant violation of this, diba, of this easement of light and view, diba? Kasi 2 meters, do you actually see one compliant, diba? Yun ang ano natin eh. Yun ang masasabi natin sa easement of light and view. Okay, so finally on property, let's discuss nuisance. So just remember the definition of nuisance under Article 694. So yung kumbaga, yun nga, yung nuisance, it's anything, diba? As you could see with 694, it's any act, omission, establishment, business condition which injures or endangers the health, annoys, offends the senses, shocks, defies, etc. So yan yung definition ng nuisance we have to remember. For nuisance, I have been waiting for nuisance to be asked in the bar examination several years already, but none has been coming so far. I'm thinking to myself, meron bang current events ngayon na lumalabas? One I could think of is the Chocolate Hills, di ba? There's a resort that was built near Chocolate Hills, di ba? So this calls to my attention the case of Aquino versus Municipality of Malay, Aklan. So in this case, we all know what happened. There were buildings that were made on the no-build zone, which were established by the local government units after Yolanda, di ba? So what happened? So there was a question as to whether or not the putting up of no-build zones was proper. Supreme Court said yes, wala namang problema if you put up no-build zones in areas like this because they could be considered as nuisance accordingly. But as to the question of whether or not they are nuisance per se or per accidents, they are considered as per accidents. Why? Because per se, they are not considered nuisance, but but there needs to be an authority declaring such to be nuisance before they can be considered as nuisance accordingly. So another case that we could refer to is the case of smart communications. Basically, there was a question as to whether or not yung ating cell sites can be removed from one place because it can be, we all know how it is, diba? Yung cell sites, sinasabi, harmful to, kakakos ng brain cancer. I mean, Supreme Court, unless you are able to prove otherwise, you cannot remove cell sites. Yan ang long and short of the case of smart communications. But we have to remember, despite current events, we have to remember this 2023 case of Aleta. So what happened here? As a general rule, swimming pools are not an attractive nuisance. Diba? Why? Because copying water is not a nuisance, but putting up structures that make it attractive to children, that's what makes it an attractive nuisance. So in this case of Aleta, ano nangyari? Basically, there were slides around the swimming pool of Sofitel Philippine Plaza. Yung anak ni Aleta dito, nabagok ang ulo, nagkaroon ng concussion yung bata. So nung nagkaroon ng concussion yung bata, of course, Aleta sued Sofitel Philippine Plaza for failure to place a lifeguard beside the swimming pool. So Supreme Court agreed with Aleta that there was a failure of Sofitel Philippine Plaza in this case. Why? Why did the Supreme Court agree? Sabi ng Supreme Court, even though as a general rule, a swimming pool is not an attractive nuisance, if there is a structure that makes it such an attractive nuisance, like slides in this case, you have to take precautions in order to prevent accidents from taking place in this area. So yun yung doctrine of attractive nuisance accordingly in this case of Aleta. So just remember that. Actually, one case that I have been waiting for to be asked in the bar exams is the case of Frabel properties. The 2020 ruling, which was the recent motion for reconsideration ruling of the Supreme Court. Kasi this case dates back jurisprudence-wise to 2014, whereby there was this question as to whether or not the noise and the heat emitted by the building in Makati should be considered as a nuisance. Supreme Court said that cannot be declared a nuisance. Why? Because sabi ng Supreme Court, it is common for a building in Makati and for the residents of a building in Makati to experience noise, to experience heat. Why? Because this is a central business district. Unless you're able to prove, like in the case of smart communications, that this is extraordinary, yung noise and yung heat emitted by the structure, which is the building in this case, you cannot say that it is a nuisance that can be abated. So yun yung tandaan natin pagdating sa Frabel Properties Corporation. This is a case I've been waiting for basically 3 years already. So I think it's gonna be a 4th year na hindi pa rin siya lalabas. Kasi wala na, lumamig na yung issue. So yun yung ano dyan. Pero just the same, di ba? Just the same. Okay, so that's property. Let's proceed to Book 3, Wills and Succession. Ito, mabilis lang tong portion na to kasi there are a few areas in succession that we have to remember. The first one we have to remember in succession are the concept of compulsory heirs. So we all know who compulsory heirs are. Basically, descendants, and in the absence thereof, ascendants, and then your wife, and then even illegitimate children. The latter of which must be proven to be your child, meaning to say the filiation must be proven. So just remember who compulsory heirs are. And before you think about the will, think first about the legitim. So ako, this is how I look at wills and succession. Before I think about the will, I think first about everything that's going on around the will. So the will, and then the compulsory heirs, and then the legitim. So with legitim, actually, there's no magic formula as to computing the legitim. Everything is placed in the law for you to read and for you to understand. Just remember always that the children have the greatest share. Why is it that the children have the greatest share? Except in instances whereby there are several children and there's a spouse remaining, diba? Equal sila. Why is it that the children always have the greatest share? Because as you should hopefully remember from our discussions earlier, yung ating property relations between husband and wife, whether absolute community or conjugal partnership of gains, it has to be settled first before the estate is determined. So, if the property relations in absolute community is co-owned, diba? So, how about conjugal partnership? Once again, in conjugal partnership, it is property belongs exclusively to one another, diba? To one or the other. So basically, it belongs to the husband or it belongs to the wife. Hence, if the husband dies, what will happen? So, if the husband or wife dies, what will happen? So basically, automatic yun, diba? Automatic yun, kalahati sila. So, kung absolute community, kalahati agad doon sa wife. Why? Because co-owned niya ang property. Kaya, ang nangyayari, mas malaki ang share ng children. Kasi sa determination ng estate under wills and succession. Because when you talk about yung persons and family relations, co-ownership agad yung sa absolute community. Halati agad nun sa wife or sa husband accordingly. Kaya mas malaking share ng children. Yun yung tandaan ninyo. yung only, kaya, and also, kaya laging nakalagay dito na ang wife or ang husband can only get a share from the disposable free portion. Hindi siya sa legitim nakakakuha. Why? Because yung legitim, children agad yun. Kasi nga, hati agad pag absolute community. Let's say conjugal partnership of gains. Pag conjugal partnership of gains naman, kunin agad ng husband or ng wife yung share niya. Kasi di ba, conjugal partnership of gains, one property of the husband, one property of wife, mixed together to produce income. Pag namatay, ano nangyari? Akin na yung property ko ulit. Na, di ba? Yung mangyayari sa conjugal partnership eh. Kaya, for purposes of settling the succession, kunin muna ng husband or wife yung share niya, saka tayo mag-determine ng ano. Kaya ang legitim, lagi na lang yan, sa children muna yan, and yung wife, laging disposable free portion. Yun yung tandaan ninyo doon. Kaya yun yung, that is how, or that is why the law is geared that way towards the children. So yun yung tandaan natin. And also remember, aside, so that's the overwhelming thought that you should remember with legitim. So sabi ko nga sa inyo, everything or the rules are there for you to remember. For you to study. There's no magic formula na, how can I, it's all in the civil code. Maniwala kayo sa akin, it's all in the civil code. Another topic that we have to discuss is the concept of preterition, in the institution of heirs for purposes of preterition. So basically, we all know institution of heirs to be a determination by the deceased of the share of the heirs, di ba? By preterition, meaning to say, tatanggalan mo ng share yung isang heir. So, the effect of preterition, we just have to remember that invalid, di ba? Kasi if you annul the share of a compulsory heir, then that shall result in invalidating such that share. Okay. Another concept that we have to remember, asked 3 bar examinations ago, declaration of heirship involves, of course, the case of Reyes versus Larlar, the 2020 ruling of the Supreme Court. Another case over which a shining light has been illuminated upon it in the past bar examination coverages, di ba? Why? Because sinasabi sa atin ng Supreme Court, important for you to know these concepts. These were not asked, except for Reyes versus Larlar. You have to remember Reyes versus Larlar is based on Article 777 of the Civil Code, whereby property shall belong to the heirs immediately upon the death of the decedent. Di ba? Yun yung ano. Kaya nga, pero there are instances whereby an heir seeks to be recognized as such. But what is the lesson that is taught to us by the case of Reyes versus Larlar? If you are a compulsory heir, if you are somebody who deserves to inherit in the property, what would be the effect? You do not need to file a suit in order for you to be declared as an heir. For purposes of what? For purposes of the settlement of the estate proceeding immediately. Why? Kasi nga, compulsory heir ka na eh. Even though it is a rule that you have to file, even though it is a rule na kailangan malaman natin kung talagang heir ka, but if you are a compulsory heir, decided as such, you just need to interject yourself in the special proceedings for the settlement of the estate before you can be considered as an heir. No need to file an independent civil action according to the case of Reyes versus Larlar. Save time accordingly. Di ba? Kita natin ito. The rights of heirs no longer need to be settled in an ordinary suit. Yun lang ang case ng Reyes versus Larlar. One needs to be, you just need to interject yourself in the special proceeding for the settlement of the estate. Another case that we have to remember is the substitution of heirs, basically yung fideikommissary substitution. So what does fideikommissary substitution mean? So basically, it involves yung a fiduciary of first heir is entrusted with the obligation to preserve to another heir the property. For what purpose? So that the property shall remain in the line, di ba? The only requirement of the law is that the person, the fiduciary heir and the second heir are living at the time of the substitution as such, or the declaration of the fidecommissary substitution, such that once it has been instituted in the will, the death of the fiduciary heir shall not result in the inheritance not belonging anymore to such line, because the right of representation can or will take place in such instance of fidecommissary substitution. And we also have to remember yung ating case ng Aquino regarding substitution of heirs, whereby we all know the ruling. The Iron Curtain principle no longer exists because, as Justice Leonen had stated in his ponencia, there is no need to discriminate on children. Hindi naman kasalanan ng child, siya ay illegitimate. So basically, that's the ruling. So finally, we also have to remember yung concept ng reserva truncal. So when we talk about reserva truncal, basically, reserva. When property is inherited by an ascendant, the ascendant is obliged to keep such property for a descendant within the third degree. Diba? Yun yung concept ng reserva truncal. We all know how it works, yung ating reserva truncal. And as mentioned here, right of representation also takes place in your concept of reserva truncal. So, for this inheritance, just remember these concepts, diba? Just remember these reasons why there is a disinheritance. So, you commit a crime, etc. There was an ingratitude towards attempt against the life. You know the enumerations here. Just remember the concepts for your disinheritance. And finally, we go to the will. I hope you appreciate the layout. Kumbaga, before you go to the will, just remember everything else. Saka ka gumawa ng will. Yun yung that will be how that's how you should view wills and succession. Kumbaga yung will nasa dulo, hindi nasa harap. So anyway, so we all know how the will works, di ba? There are two kinds. We have your notarial will and your holographic will. So basically, your notarial will, of course, as to its contents, wala kang magagawa dito. It's just the formality that we have to comply with. So basically, there must be an attestation clause, and the will itself must be signed by the testator, and the witnesses accordingly, di ba? What is the effect if there is a failure to affix signatures in the places where there needs to be signatures affixed? So jurisprudence varies intent, diba? If the failure to sign is intentional, of course the will shall be void because there is a failure to communicate the true intent of the testator. If there is no such intent, then the will shall be valid. It's just considered by law to be inadvertent. So basically, it's up to the lawyer to prove that hindi naman kasalanan niya ng testator and ng witnesses. So just have to remember to represent your client properly in this scenario, diba? So that's how the notarial will is affected. As I mentioned, failure to sign one page of the will, mere inadvertence, yun yung natin. Pero syempre, also have to remember yung sa attestation clause natin, because the attestation clause, basically, it's the proof. You remember with our judicial affidavit, in relation to judicial affidavit, this is what is required of lawyers nowadays, that you executed that the witness executed the judicial affidavit, you did not coach, etc., etc. Pareho lang to sa attestation clause, that the witness signed in the presence of one another, etc., etc. Yun yung attestation clause natin. So, that is why it is required that attestation clause must be also signed by the testator, by the witnesses, not the testator, the witnesses, because this is the proof that the witness was executed in accordance with the requirements of the holographic will. So basically that's how we go about. Those are what you should remember with the formalities of your will. And finally, with your revocation of the will. So nakita ninyo how it goes, di ba? Do not copy my outline because that's a book that will come out next year. Okay, so yun na. Revocation of wills. So yun yung natin, yun yung sa revocation of wills naman, we all know how it is, yung tearing, alam naman natin yun yung sa tearing, for so long as there is an intention, tearing, burning, mutilation, if it's not intended, there's no revocation. If it's intended, then you know the effect. So those are the areas that you have to remember in wills and succession. So let's proceed now to oblicon. Konti na lang. We will, I hope that you're still able to follow, yung ating discussion. And yun nga, this is my aid to all of you. Sana pumatok, di ba? Sana pumatok yung natin, yung tips natin. Kasi everything you could basically zero in on the areas year in and year out. Just take into consideration current events, just take into consideration new developments in law and jurisprudence, be able to forecast areas. So obligations and contracts. Let's start with oblicon. In obligations and contracts, it's important for us to remember, first of all, the concept of estoppel. Why is estoppel at the front? Because as also stated in my book, those are the means by which an obligation is created. So, syempre, we have the classical enumeration under your obligations and contracts of the law, contract, will, law, contract, quasi-contract, etc., delict, quasi-delict. I include there in the discussion yung ating estoppel and yung natural obligations. Natural obligations, I will not tackle anymore. Pero estoppel, you have to remember, this is also a way by which an obligation is created. So in terms of an estoppel, always remember yung means by which it is created. So basically, through estoppel, you are precluded from denying the existence of something that you admit. So basically, estoppel has to do with the actor of the same. It does not have to do with the obligee, so to speak. It's something to do with the obligor. So basically, if you promise somebody something, even though you have no intention of actually fulfilling your promise, and then it's accepted by the recipient of the promise, estoppel dictates that you are now precluded from denying fulfilling your obligation. So yan yung concept natin ng estoppel. Estoppel, it's a concept that you have to remember always when you study obligations and contracts, because hindi naman ito yung main question. Pero this is a question that can be part of the question can be part of the main question. Parang pasagi lang siya doon sa question para panglito sa inyo. So yun yung tandaan natin pagdating sa estoppel. So proceeding further, on obligations and contracts, we have to remember the nature and effect of obligations. So when we talk about the nature and effect of obligations, we all know the obligation of complying with the requirement of the diligence of a good father of a family. Those are easy to remember. Just remember for the nature and effect of obligations yung concept of delay. So alam naman natin pag delay, it only starts whenever there's a demand, whether judicially or extrajudicially. So meaning to say, there's a demand letter sent to you, there's already considered delay, except as enumerated by the law, diba? Except as enumerated by Article 1169 of the Civil Code, which provides that if it is agreed upon by the parties, okay, if time is of the essence, so alam naman natin yung na yan. And remember, in reciprocal obligations. That in reciprocal obligations, there is no obligation to comply with what is incumbent upon one if there is no capacity of the other to comply with what is incumbent upon the latter. So what do we mean to say by this one? There is a case involving ito. Let's say itong Richardson Steel. There is a failure of the bank to release the full proceeds of the loan. So let's say yung Richardson Steel obtained a loan of 10 million pesos. Richardson Steel did not pay. Sabi ng UBP, you have to pay already because we released 8 million pesos. Sabi ng Richardson Steel, no, I obtained a loan for 10 million pesos. You released 10 million pesos before I pay the obligation. Sabi ng Supreme Court, tama si Richardson Steel. You have to release the whole amount or the whole proceeds of the loan before there can be considered an obligation to comply with the reciprocity of the obligations between the two parties. Meaning to say, as we could see in Article 1169, in reciprocal obligations, you only have to comply when there has been a compliance when there's a readiness to comply by one of the obligations or the prestations that is required upon him. So yun yung sinabi dito sa Richardson Steel Corporation case. Hindi mo ni-release yung 10 million pesos, 8 million lang ni-release mo. Ano lang yan, figurative amount lang yan. Hindi mo ni-release yung 10 million, 8 million lang ni-release mo. Anong effect nun? Hindi kailangan magbayad ni Richardson Steel. I-release mo yung 10, saka mo i-require magbayad si Richardson Steel. Another case, ito kaya, pwedeng lumabas to Itong si Pantaleon versus American Express. So we all know, I hope we all know, di ba? I hope you know, yung dito sa Pantaleon, basically what happened, the credit card did not process immediately the payment. Meaning to say, yung isang nag-shopping, nag-swipe siya ng credit card. There was a delay in the processing of the credit card, such that hindi na nabili ni credit card user yung kanyang item na gustong bilhin. Dinimanda niya ngayon si American Express. Sabi niya, you are obliged to process the credit card transaction immediately. Ano ang sabi ng Supreme Court? Sabi ng Supreme Court, there is no delay on the part of American Express International. Why? Because when a credit card is swiped, it does not constitute an immediate obligation on the part of the credit card company to process the transaction. Sabi ng Supreme Court, once the credit card is swiped, it is an application for a loan filed by the owner of the credit card. Basically yan. Yung owner ng credit card, it's an obligation, it's an application. Pwede pong mangutang. Yun ang point ng Supreme Court. Pwede po bang mangutang? Sabi ng Supreme Court, hindi yun, bayaran mo to. Pag nag-swipe ka ng card, hindi ganun ang premise na, bayaran mo tong, ako gusto kong bilhin. According to the Supreme Court, pwede bang mangutang? Yun ang premise ng credit card transactions. Pwede lumabas, di ba? Pwede lumabas yan. Natin yan. So so proceeding further, let's discuss the kinds of obligations. So, kinds of obligations, we have your pure, unconditional, etc. The important obligations that I want you to focus on are yung solidary and obligations with a penal clause. So when we talk about solidary obligations, what should we remember? There is no presumption that just because two persons are indebted to one person that there is a solidary liability already. There is a presumption only of a joint liability, meaning to say you pay your respective shares in a solidary obligation. In an obligation. So, syempre, you could imagine the scenario. One person, creditor, then to debtors. Is there a presumption? Once again, no. The only presumption is that they shall be required to answer for their respective shares. Unless what? Unless the contract between the parties expressly declares that there is a solidary liability on either of the debtors, such that the creditor can file suit against one of the debtors for the collection of the entire obligation, unless it is stated in the agreement. That is the presumption given by the law. So, yan ang ano natin. Let's proceeding to an obligation with a penal clause. Just remember these rules that are enveloped in an obligation with a penal clause. Foremost for you to remember is that you cannot replace compliance with an obligation with the payment of a penalty in an obligation. So yun yung number 2 natin. The debtor cannot exempt himself from the performance by paying the penalty. Kasi nga, penalty clause is dependent. Penalty in an obligation is dependent on what? Is dependent on your failure to comply with the obligation. So just remember these rules in the computation, in an obligation with a penal clause. There are several jurisprudence, quite frankly, that have come out regarding the court fixing the penalty that should be paid for in an obligation with a penal clause. So it's simple yung penalty. If it is too excessive, basically what the Supreme Court has said is too excessive is if it is at least 3 times more than the legal interest rate. So if it is 3 times more than the legal interest rate, the court can step in and fix the penalty rate. Important for you to remember, in an obligation is one involving Article 1191 on the violation of a condition. As to the remedy of rescission that is available. It's important that we take out the distinction between Article 1191 on rescission and Article 1381 on rescissible contracts. Because when we talk about rescission under Article 1191, it is always premised on the failure to comply with a condition in an obligation. While under Article 1381, it is premised on the failure on a lesion that has been an lesion in an obligation or in a contract. What do we mean to say? The best example, kasi 1191, we all know the effect, diba? You have to return everything except in instances where, like in the case of solid homes, sorry. So, in terms of your rescission, just it is important for you to distinguish between the two. Kasi basically when we talk about it, the classic example of rescission under Article 1191 involves violation of a condition. Let's say in a case decided by the Supreme Court, let's look for that case. Let's say in a case decided by the Supreme Court, there was a failure to comply with the condition of the NHA that you cannot sell the property within a period of 5 years. In that instance that you have failed to comply with the condition in an obligation, what is the result of that? That opens you up for rescission under Article 1191. But if you compare it with Article 1381, let's just look at this slide. There has to be an economic prejudice under Article 1381 for there to be a rescission under the chapter on rescissible contracts accordingly. So yun yung effect na, yun yung difference nung 1191 and Article 1381. So yung 1191, we have to remember on the kinds of obligations, whenever there has been a violation of a condition in an obligation, like yun nga, for example, selling within a period of 5 years, the effect is that rescission is available. So violation of a condition. But yun nga, remember, for rescissible contracts, you have to compare it in that there must be a lesion that takes place. So the primary example of lesion is whenever 1/4 has been lost on the property, as we will discuss later on. So yun na nga. Let's proceed. Finally, on the topic of extinguishment of an obligation with obligations. So, what should we remember in extinguishment of an obligation? Another current events that we have to take note is that of inflation. Diba? What should we remember with inflation? Inflation only takes place according to the case of Citibank versus Sabiniano, a 2007 ruling of the Supreme Court. Extraordinary inflation only takes place when it is declared by the BSP or any other monetary authority authorized so to do. Yun yung instance whereby there can be extraordinary inflation supervening. What's the effect if there's an extraordinary inflation supervening? Let's say the obligation is to pay 10,000 pesos per month for a period of 10 years. If there is an extraordinary inflation supervening, let's say the value of the peso at the time of 10,000 pesos is now, let's say, 50,000 pesos, then the obligation may be adjusted accordingly. But absent such declaration, once again, by the BSP or any other monetary authority for this purpose, there can be no adjustment of the payment of the obligation. So yun yung tanda natin sa extraordinary inflation. Furthermore, on the topic of extinguishment of an obligation, we also have your novation. So basically, when we talk about novation, it involves either a change of the object or the principal conditions of the obligation, or a change of the debtor or the creditor accordingly. So what should we remember with novation? The essential elements of novation, just for you to have an easy understanding, it's the incompatibility between the first and the second obligation. Yun yung tandaan natin para lang hindi mo kailangan i-memorize to a previous valid obligation, agreement of all parties, extinguishment of validity of new one. It's the incompatibility of the first and the second obligation. So such that ano ba yung dapat nating maalala sa novation? For novation, there can only be novation if it has been, number one, explicitly stated, meaning to say there is an agreement between the parties regarding novation, or there is an incompatibility. Ano bang example natin dito? There is a case decided by the Supreme Court whereby there's a question. A debtor let's say a debtor was not able to pay his obligation, but somebody, not but, and somebody came in and said, okay, I will now pay for, let's say, A's obligation. Sabi natin, si A was not able to pay, and X came on and said to creditor, let's say M, that, okay, I will now pay for the obligation of Mr. A. Question: was there a novation in such a scenario? The answer given by the Supreme Court, there was no novation. Why? Because even though the debtor A in this case was somebody came to the rescue of the debtor A in this case, what happened according to the Supreme Court? There was no novation that took place because the obligation of A remains. So since the obligation of A remained, what happened? There can be no such novation because under the test of incompatibility, there should be basically that's the term. The first and the second obligations are incompatible on each and every point. Sabi ng Supreme Court, pinalitan mo lang yung, kumbaga, the person just assumed the obligation of another. That is not novation. So, kasi hindi naman sinabi na, oh, A is no longer liable here. Ang sinabi lang ni Mr. X, I will pay for the obligation of A. Hindi naman sinabing, I will pay for the obligation of A, and A can no longer be held liable. Kung ganun ang nangyari, there is definitely novation. But without such, yun ang natin. Another item or another point that we have to remember with novation is that if there's a new agreement that recognizes the old agreement, there can be no novation. So what is the overarching point that we have to remember with novation? The overarching point that we have to remember with novation regarding the change of the object or the principal conditions thereof is that for there to be novation, let me rephrase. The overarching point in these scenarios is that the law there is a presumption against novation in the change of the object or the principal conditions. Why? Because if there is because the law seeks to prevent a debtor from escaping from his liabilities. Kaya kumbaga, the overarching theme of novation is that unless otherwise expressly declared, unless otherwise expressly incompatible, you have to pay for your indebtedness. Even if somebody said, ako na magbayad ng utang mo, pero hindi naman sinabi sa obligation, sa contract na, sige ako na magbabayad talaga ng utang niya, wala na siyang pagkakautang, there is still indebtedness on your part. So just remember that as the overarching theme for novation. So, and also, but the overarching theme only applies to number one, change of the object or principal conditions, because we have to remember that in instances whereby there is a change or substitution in the person of the debtor, what is the requirement of the law? If there is a substitution in the person of the debtor, even if it is done so without the consent of the debtor, it's okay. It's allowed by law that there shall be a novation. How about the creditor? The creditor shall only be allowed to be changed, but with the consent of the debtor. But the point here is, hindi ganun ka-stricto. So, except for number one, yun lang yung stricto natin na, okay lang, incompatible or expressly stated. So, that is what you have to remember with novation. Novation class is a concept that we have to remember kasi it's one of those that seems to always come out in the bar examination. So just remember overarching thoughts, tests of incompatibility in order for you to come up with an answer. the same. Let's proceed now to contracts. We all know the essential requisites of contracts, so no need to place them here, di ba? Yung ating cause, object, and then yung consent, di ba? I cited here yung nature of advertisements for our contracts. Under the topic on consent, yung ating advertisements, always remember that just because somebody placed an advertisement, let's say cell phone for sale, 10,000 pesos. If somebody says to you, okay, akin na yung, bilhin ko yung cellphone mo, 10,000 pesos, are you required to accept it? If somebody says, at the same time, bilhin ko 11,000, are you required to accept the 10,000 peso offer? The answer is no, because Articles 1325 and 1326 are clear. These are not definite offers, but mere invitations to make an offer. So always remember that, yung in terms of advertisements. Moving forward on the essential requisites of contracts regarding consent. So always remember yung vices of consent natin. Ano ba yung vices of consent natin? We have your mistake, violence, intimidation, undue influence, and fraud. Remember the scenarios or the keywords that I highlighted here for you to note what would constitute yung ating grounds that would be considered as vices of consent. Let's say mistake. If it is not the principal cause which moved one to purchase something or enter into an obligation or a contract, is that enough to cause for the nullification of the contract? The answer would be no. Remember, the keyword is principally moved. How about violence? It must be serious or irresistible force. So what do we mean serious or irresistible force? Basically, somebody cannot, if somebody, let's say if a 10-year-old is threatening me with violence, should I be afraid? The answer is no, di ba? How about intimidation? Siyempre, the keyword here in intimidation is reasonable and well-founded fear of evil. How about undue influence? There should be an influence. So let's say, for example, a company said to a lawyer who is not employed in the said company, "Oh, I do not want to execute this contract because our lawyer said so." Should the lawyer be allowed to evade such, or should the lawyer be compelled to not fulfill the can the lawyer sue for nullification of the contract just because of undue influence? The answer is no, because what influence does another company of which the lawyer is not employed in to compel another? So in short, there's no undue influence. And then fraud, we all know how fraud is, insidious words or machinations, but we have to remember, for fraud, must be relied upon. So that is why yung fraud natin, it must also be related to the principal reason to move one to enter into a contract. So I don't know kung itatanong to na itong reformation, pero just take note of these concepts, yung reformation of instruments whereby there is a perfected agreement between the parties, but in order to communicate the true intention of them, reformation of the instrument is sought. Also remember yung mga instances whereby there can be no reformation. So like in this one, yung simple donations, inter vivos, wills, and when the real agreement is void. So there can be no reformation in such a scenario. Rescissible contracts we have discussed earlier. So remember once again the effect of rescission. So rescission, return everything, diba? Alam naman natin rescission, balikan ng naibigay. So just to compare rescission under 1191 to 1381, just look at the grounds. For 1191, once again, there's a violation of the condition. In this one, there is a damage that has been incurred. So just to remember, ito nga, contract entered into by a guardian, more than 1/4 of the value is lost. And then in representation of absentees, same. Undertaken in fraud of creditors, another instance. Okay. Item under litigation which is sold, another instance. Okay. All other contracts declared by law to be subject of rescission. So yun yung tandaan natin. And remember also that for purposes of your rescissible contracts, it is under the concept of action Polyana, whereby it is subsidiary to other remedies that are available. So it cannot be instituted as the first remedy. So meaning to say, you have to seek specific performance first before you can seek for rescission. Kumbaga, that's the short way of saying yung action Polyana natin. Another concept that I don't know if it can come out is yung unenforceable contracts natin. This is of course a popular topic among professors of obligations and contracts. I remember my professor then. Basically, we were not able to discuss majority of the topics in contracts because we ran out of time. But he made sure to discuss this concept of unenforceable contracts under Article 1403. So just remember this unenforceable contracts. So aside from number 1, okay, given no authority, or number 3, both parties are incapable of giving consent, yung ating number 2 simply hinges on whether or not there's a memorandum that is in writing, okay, and it's not to be, kumbaga, there's a memorandum or it is in writing. So remember that whenever there is a memorandum that has already been agreed upon by the parties, the contract shall be enforceable. So, kumbaga, makita mo naman kasi ang enumeration dito, an agreement that is not to be performed within a period of 1 year, special promise to answer for that. As a rule, it's not enforceable if it is not in writing. But if it is in writing, it is now enforceable. That's the best way to look at the concept of an unenforceable contract. So, finally, for void contracts, just remember once again yung ating essential requisites of contracts. So, absent any of these essential requisites, you have your void contract, di ba? So, absent consent, object, and then yung ating cause. There is no contract. So, there's a void contract accordingly. So that finishes our obligations and contracts, and now let's proceed to special contracts. There was a question, kumbaga, nakita niyo naman book 4 yung nakalagay. There is a question before nung law student, nung college pa lang ako, legal management. Is there a book 5? There's no such thing. Okay, there's no such thing as a book 5. There is just special contracts under book 4. So what are the special contracts that are important for us to discuss? Of course, we start with sales. So by the contract of sale, one of the contracting parties obliges himself to transfer ownership and deliver an object certain, and the other to pay thereof a price certain in money or its equivalent. It's important for you to remember the stages of a contract of sale. So, which are negotiation, perfection, and then consummation, because of the concepts of an option contract, the right of first refusal, accordingly. But before that, let's proceed to this 2023 ruling of the Supreme Court involving bayanin. So, what happened in this case of bayanin? There was a deal that was brokered between agents of Ayala Land and then yung kay Luciutan na company, Eaton. there was a deal that was brokered between two parties. I would assume ito yung sa Pasig. I mean, please correct me if I'm wrong. Pero I would assume ito yung nasa Pasig, yung along C5. So there was a deal brokered between the two. Naturally, because it would entail payment of brokers' commissions up to the millions of pesos because of the billions, because this deal involved billions of pesos. So the two companies sought to evade their obligation. Then when they sought to evade their obligation, they were sued by the brokers. So anong sabi ng broker? Sabi ng broker, we are deserving to be given our commissions. What did the companies say to that? Sabi ng companies, you are not, because there was no perfected agreement between you two. Kasi what happened in this case, when Ayala and the Luciatan group were close to an agreement, they pulled out the brokers and they said, ayaw na namin gamitin yung broker. Kami-kami na lang mag-uusap. Kaming principals na lang. What did the Supreme Court say? Supreme Court said that the procuring costs, so basically in relation to proximate costs natin to, the procuring costs of the transaction were the brokers involved. So, in essence, sabi ng Supreme Court, there was already a perfected contract between the parties. So, there was already a perfected contract between the two companies. So, perfected contract between the two companies because the two brokers agreed. So, there was procuring costs already. So, in relation to this nga, sabi ko sa inyo, it's important to know the stages of the contract because of the concepts that follow. Basically, in the stages of a contract, yung importance ng perfection differentiated with negotiation cannot be understated. Why? Because there are instances whereby the parties mistake negotiation with perfection. So we are well aware that if there's an offer and counter offer that has been forwarded between parties, that just constitutes what? That just constitutes negotiation stage of a contract. But if there is an acceptance of an offer, etc., there is already a perfected agreement. Where does the option contract come into the picture? The option contract comes into the picture under Article 1479, whereby or involving an accepted unilateral promise to buy or sell a determinate thing. It shall be binding upon a promisor under the Civil Code. If what? If it is supported by a consideration. So let's say, for example, an individual X promised to A that he will buy his car. So sinabi kasi ni X, nakita ko yung kotse mo for sale, 300,000 pesos. Let's say Subaru. Mura. Subaru, 300,000 pesos, Subaru Legacy. So, bilhin ko na lang, 300,000. Sabi ni A, sige, no problem. Bilhin mo. Okay. Kailan mo bilhin? Bilhin ko in 10 days. Okay. 9th day, biglang umurong si X. Sabi ni X kay A, ayoko nang bilhin kasi marami palang problema yung kotse mo. Dinimanda ni A si X. What is the effect? Anong sabi ng Article 1479? An accepted unilateral promise is binding upon the promisor if it is supported by a consideration. So, in our example, was it supported by a consideration? No. So, this just constituted an option contract. As compared to what? As compared to an earnest money. Let's say, same example, 300,000 pesos. X, bigyan kita ng 30,000 pesos earnest money para bilhin ko yung kotse mo in 10 days. Para akin na yan, hindi mo ibibigay sa iba. Okay, sige. Yung earnest money na to, basically, after nito, 270,000 pesos na lang babayaran ko sa'yo. Okay, payag si A. Biglang umurong si A. Sabi ni A, ay, teka lang, may buyer yung kotse ko ng 330,000 pesos. Soli ko na lang yung 30K mo. what happened? There is already a perfected contract of sale because earnest money forms part of a perfected contract. It is also commonly known as down payment. So because of this earnest money, a suit for specific performance can be filed by the buyer of the car as against the seller. When we compared with an option contract, because the option contract is just an accepted unilateral promise without a consideration, there is no binding, the buyer cannot be compelled to buy from the seller. The question is, what if it is now supported by a consideration? So, balik tayo sa example natin. What if X said to A, X, wala pa kasi akong 300,000 pesos, pero may 10,000 ako. Bigay ko muna sa ito para lang i-reserve mo sa akin yung kotse in 10 days. Kasi in 10 days, tingin ko meron na akong 300,000. Okay. So, in 10 days, meron na akong 300,000. Was this an option contract? The answer is yes. If this is an option contract, what would be the effect if there is a failure of A to sell the car to X at the end of the 10th day, if X has already tendered an offer to buy the car? The answer is X can sue A for damages. But can X force A to sell the automobile to him? The answer as given in case decided by the Supreme Court is that no, you cannot force a person to sell the automobile. You cannot force a person under an option contract to sell. Why? Because this only opens up a suit for damages accordingly. So that's the ruling of the Supreme Court. In relation to which, imperfection of contract natin, once again, let us discuss naman yung right of first refusal. So when we talk about the right of first refusal, what should we remember? It is an option to purchase that is usually communicated by a buyer to the seller in an auxiliary agreement. So usually yung auxiliary agreements nito come in the form of your lease contract. So when you talk about the lease contract, where is the right of first refusal there? Usually, if there is a lessor and a lessee in a lease contract, syempre naturally, when there is a lessor and a lessee in a lease contract and there's an agreement between such lessor and lessee, what agreement would usually comprise a right of first refusal? An agreement that would comprise a right of first refusal would usually involve giving the lessee the option to purchase the property that is being occupied by the latter from the lessor if the lessor decides to sell the property. So that's a right of first refusal. It is binding in its effect such that if the lessor violates this agreement and there is a failure to offer and there is a similar offer to a third person who is the buyer of the leased property, it opens up the lessor and the third person to rescission accordingly. So the lessee can seek rescission of the agreement, and seeking rescission of the agreement, what would be the effect? The lessee can thereafter purchase the property from the lessor. Yun yung concept natin ng right of first refusal. Another concept of right of first refusal, just because I'm a sports lover, right of first refusal involves basically yung free agency contracts. Let's say in the NBA, a contract of a rookie is subject of ano bang tawag nila doon sa contract na yun? Yung basically yung contract nila na if your mother team matches the offer of another team, then you have no choice but to return to your mother team. So yun yung examples ng right of first refusal. So remember, a right of first refusal in comparison with your option contract, in comparison with your earnest money. Why are these concepts important? Because in relation to the stage of the perfection of the contract, these separate ones. Yung option contract communicates to us that that is not yet a perfected contract of sale. Yung yung earnest money communicates to us that the earnest money is already a perfected contract of sale. While a right of first refusal also communicates to us the stage of perfection of a contract between the parties. So kaya important itong concepts na ito. Another concept that we have to remember with sales involves yung delivery of the thing. Di ba? Yung in terms of our elements of the contract of sale, you have to remember yung definition whereby by the contract of sale, one of the contracting parties obliges himself to transfer ownership of and to deliver a thing. I feel that there can be a scenario whereby the old case of EDCA publishing can be asked in the bar examinations. This is a 1990 ruling. Basically, what happened in the case of EDCA publishing, there were books that were purchased by an individual, not yet fully paid for, but being paid for in installments. Later on, it was discovered by EDCA publishing that the person saying that he is who he is, let's say he's saying that I am Mr. Y, a professor in LaSalle, was determined by EDCA publishing to be not actually a professor in LaSalle. Henceforth, they swooped in, raided the house of Mr. Y, and took all of the books. Sabi ng EDCA publishing, you are not Mr. Y. When sued, EDCA publishing alleged as a defense na he's not Mr. Y eh. So there is no perfected contract of sale. Anong sabi ng Supreme Court? Ano ngayon kung hindi siya si Mr. Y? Sabi ng Supreme Court, the fact is, if you define a contract of sale under Article 1459, you transferred ownership of and delivered a thing to another person. Once there is a transfer of ownership and delivery of the thing, what's the effect of the sale? The effect is that there is already a perfected contract of sale. Yun yung tandaan natin pagdating sa perfection of the contract of sale by mere transfer of ownership and delivery, as may be seen in the case of EDCA publishing. Ako, I'm holding out hope that this case comes out because it's a beautiful case decided by the Supreme Court. So, yun lang. Kaya ako, I hope it will come out at some point. So, let's move forward to the factors affecting contract of sale. Another factor that we could consider is the gross inadequacy of the price. So, when we talk about the gross inadequacy of the price, we are referring to an instance whereby, let's say, an individual sells an item. Let's say a cell phone was sold for, let's say a cell phone was sold for 2,000 pesos. Let's say 10,000 na lang. Let's say a phone was sold for 10,000 pesos, but its value is actually 30,000 pesos. Can you seek for the nullification of the agreement just because of the gross inadequacy of the price? The answer is no. Why? Because unless there's a showing that the consent was vitiated, there could be no such nullification of the agreement just because of the gross inadequacy of the consideration. In short, what the law is telling us, it's your fault if you sell it for such a low price. Wala namang nagsabi sa'yo na ibenta mo yan at that price. Kaya nga, the only requirement of the law is that there is a vitiation of the consent. Kaya that will Okay. let's now discuss yung remedies of the failure to pay the price. So when we talk about the remedies of the failure to pay the price, it's important for you to just have a working idea of what is the effect of the failure to pay the price. So if there's a failure to pay the price, number one is the remedy of specific performance. Another remedy available is to recover damages. But as we had emphasized earlier on the concept of rescissible contracts, it is an action Pauliana. It is a subsidiary remedy available, yung rescission natin. So the first remedy, as always, is specific performance if there is a failure to pay the price. So another concept that we have to remember under your law on sales is your express warranty as compared to your implied warranty. Because your implied warranty, it's obvious eh. Implied warranty against hidden defects, implied warranty against eviction, di ba? Those are concepts that we are well familiar with. How about an express warranty? What is an express warranty? The overarching point of an express warranty that we have to remember involves that it is the prime moving factor in the purchase of a thing or the object of a contract, whether movable or immovable. What do we mean to say? As mentioned, or as may be seen in Article 1546, it induced the buyer to purchase, such that in the case of Philippine steel coating, ano yung masasabi natin na effect if there is a violation of the warranty, express warranty? Kasi ano ba nangyari dito sa Philippine steel coating? Basically, there was a question lodged by the buyer. I will use your paint for the roofing of my bases. So sabi dito sa Phil Steel Coating, yung nagbebenta, okay po yung paint namin, kalimutan ko ng tawag doon sa kasi it's very technical, very engineering term yun eh. So okay po yung paint namin as compared with a primer kasi hindi kakalawangin. Lo and behold, after several months, kinalawang yung bubong ng bus. So dinimanda ngayon ng buyer yung seller. There is a violation of warranty. Sabi ng seller, kinausap mo lang yung yung engineer namin who communicated to you that that this is compatible with your buses. Sabi ng Supreme Court, precisely, the buyer relied upon such representation made by the seller. And the seller is an expert in the field, an engineer, diba? Such that because of such reliance, he purchased. Hence, violation of warranty, express warranty. So remember that. Remember the key concept in express warranty, it's that inducement to purchase. Yun yung masasabi natin sa express warranty. Now, let's proceed to agency and trust. So, as we all know, partnership is not included in the coverage of civil law. So, it's with commercial law. So, take note of the discussions of your commercial law professor there. The important concept that we have to remember with agency, we are all aware naman kung anong effect kapag halimbawa there is a violation of the terms of the agency. It's not binding on the principal, or if it is ratified by the principal, then okay, of course it's binding upon the principal. But otherwise, it's not binding. So that's the long and short of agency, except for the concept of implied agency. What's the concept of an implied agency? Basically, implied agency has to be inserted in the discussion of agency, because if there is no such implied agency that is included in the law, then there could be a scenario whereby an individual misrepresents himself to be acting for a principal and then denies later on such act of representation, acting for and in behalf of a principal. Henceforth, via the principle of estoppel, via implied agency, you are considered as an agent and you are considered as binding the principal. Implied agency is especially relevant whenever we consider that it is important, the importance of the principal accepting the representation made by the agent who impliedly clothes himself with authority. So sabihin natin, an agent says, a person claiming to be an agent of the principal says, yung bahay ni Mr. A is being sold by him for 10 million pesos, let's say. Nalaman ni Mr. X / principal na binebenta ni bahay ni Mr. A nga pala. Nalaman ni Mr. A na binebenta yung bahay niya nitong si implied agent ng 10 million pesos. May kumagat. Sabi ng isang buyer, ay sige, bilhin ko. Sabi ni Mr. X, bilhin ko yung bahay ni Mr. A for 10 million. Sabi ni Mr. A, teka lang, hindi ko man binibenta ng 10 million yung bahay ko. Sige na nga, sabi ni Mr. A, sige na nga, okay lang, magre-retire na rin naman ako. Benta ko na sa'yo for 10 million. So, that's an instance of an implied agency. That protects not just the principal, because there's a need of acceptance of the implied agency, and also the agent. If, for example, the agent seeks commissions, seeks anything in return for acting as an agent, then that is the protection given to both parties. Kasi for the principal, cannot be bound by the acts of the agent without your consent. And for the agent, if the principal accepts your representation, then there is such an implied agency that is existing. And henceforth, all of the relative benefits and liabilities shall attach. So that's your agency. Credit transactions naman tayo. So for credit transactions, just remember yung ating distinction between commodatum and mutuum. You could see in the definition yung ng Article 1933, yung distinctions between mutuum and commodatum. Mutuum, of course, involves a contract of simple loan, while commodatum involves an obligation to borrow something and return the same thing at a certain period of time. In credit transactions, we also have to remember the benefit of excussion that is present in your guarantee. What is the benefit of excussion? Basically, once the debtor defaults in his obligation, the benefit of excussion prevents the creditor from seeking or calling upon the guarantee to answer for the obligation by allowing for the guarantor to point out available properties of the debtor before he is called upon to answer for the obligation. That is the benefit of excussion. But of course, we know what guarantee is. Guarantee basically means by word of mouth, a third person guarantees performance or fulfillment of an obligation that has been entered into by another person. Another concept that we have to remember with with credit transactions is the essential elements of a pledge and mortgage. So always remember, in pledge and mortgage, its nature as an accessory obligation. So when we talk about its nature being an accessory obligation, it is what it is. It's basically entered into to secure the fulfillment of a principal obligation. In terms of your pledge, basically it involves movable property, and for mortgage, it involves either immovable property under real estate mortgage or movable property under your chattel mortgage. So just remember the distinctions and the essential elements of the same because they are similar. When you talk about pactum commissorium now, we refer to, of course, an instance whereby there is an automatic transfer of ownership of the property from the creditor coming from the debtor. So basically, it's an agreement between the parties na once you default in your obligation, property is automatically mine. So this is expressly prohibited under the law. One of the few contracts that is expressly that provides for an express prohibition under the law. Another consideration that we have to remember on pledge is the effect of default. We cannot discuss. We need not discuss this in mortgage because, as we are well aware of, this is expressly this has been expressly removed from the coverage of the bar examinations in civil law, yung sa mortgage. Kaya let's just proceed to the pledge and the effect of default. So when we talk about the pledge and the effect of default, what can we remember? It involves a sale of the thing pledged at public auction also. So ganun lang, pareho lang sila ng real estate mortgage. Finally, on your mortgage, we just have to take into consideration the so-called dragnet clause. What's the dragnet clause? Basically, it involves an agreement whereby other future agreements shall be covered by a mortgage that has been entered into by the parties. The essential requisite of a dragnet clause is that it must be expressly stated in the agreement. The only reason why dragnet clauses are rendered ineffective to secure future obligations is if it is not expressly written therein. Yun yung yun yung masasabi natin sa dragnet clause. Another inclusion of the coverage is our Personal Property Securities Act. So when we talk about Personal Property Securities Act, this is a spin-off of our mortgage, so to speak, of personal property. Basically, it allows for personal property to be considered as security for an obligation, so that basically there can be an extension of items that may be considered securities for an obligation. So kaya nga, when we talk about Personal Property Securities Act, how is it implemented? Basically, by the two agreements that you could see in the slide, by a control agreement or by a creation of a security interest. When you talk about control agreement, it's basically an instance whereby, for example, bank deposit, the creditor is given the authority by the bank to determine what to do with the debtor's bank deposit in the event that the debtor defaults in the obligation. So yun yung control agreement, kasi there is a control given to the creditor as to what will be done to the bank deposits just in case of a default. It also applies to commodities, securities, and other agreements that may be covered by movables, so to speak. Security interest, this is one, based on my personal knowledge, that is not yet executed or implemented by the Register of Deeds. The Register of Deeds has to come up with an implementing rules and regulations on security interest before it may be considered as part of your Personal Property Securities Act. But basically, when we talk about security interest, it involves much like a real estate mortgage. It involves the Registry of Deeds creating a registry of movable properties which shall be considered as securities for an obligation. So, what movables are involved, as you hopefully have learned from your Personal Property Securities Act, anything under the sun except for ships and airplanes. Diba? Yun yung masasabi natin na covered by the Personal Property Securities Act. As for the effects of default, what can we say as to the effects of default? So basically, if there is a default of the debtor, there is no need for a public auction, but it is an option available. Kasi according to the law, it may be disposed of, the securities involved here, in publicly or privately accordingly. So yun yung masasabi natin na effects of default under Personal Property Securities Act. So finally, let's proceed to torts and damages on our discussion to wind up our lecture. And this is basically 3 hours pa lang, 3 hours and 10 minutes pa lang ata. So hopefully maano ninyo to. Okay. So hindi masyado mabilis for you. But anyway, so yun nga. For torts and damages, just remember the definition of quasi-delicts. So when we talk about the definition of quasi-delicts, any act or omission by which damage is incurred by a person and there's no pre-existing contractual relationship, and furthermore, that there is fault or negligence on the part of the person causing damage. So yun yung essential requisite that we have to remember with quasi-delicts. So in relation to negligence, let's just discuss some important concepts on quasi-delict, the concept of less clear chance. So what do we mean by the doctrine of less clear chance? So when we talk about less clear chance, it is an instance whereby what? It's an instance whereby there are 2 negligent parties in one scenario. And 2 negligent parties, of course, seek to claim damages for the negligent act of one or the other. But one is able to claim damages as against another just because there is an appreciably later time whereby the negligence has been performed, and thereafter this negligence has led to an opportunity to evade liability via a last clear chance. So ano ba yung favorite example natin dito? Yung favorite example natin si Picard versus Smith, di ba? Yung si Picard versus Smith, ano ba nangyari doon? Yung isa horse-drawn carriage na tumatakbo doon sa kontra ng daan. Basically, wrong right of way. Yung sasakyan naman, running on its own right of way, of course, ran over the carriage of, I can't remember which is Picard and which is Smith in that scenario. Pero there was, of course, a question as to who is liable between the two. Liability was, of course, given to the automobile because it had the last clear chance and opportunity to evade the accident, so to speak. So yun yung last clear chance. Res ipsa loquitur, another concept that we have to res ipsa loquitur, another concept that we have to remember. Basically, when we talk about res ipsa loquitur, the thing speaks for itself. Alam naman natin yun yung phrase that comes into mind when we talk about res ipsa loquitur. So, in instances of your res ipsa loquitur, always remember that there is negligence that is assuaged, yun yung nasa isip ko. There is negligence given to somebody who has control of the thing which causes the damage, such that if the person who has control of the thing was not negligent in his act, then there could not be any damage that may be incurred. So yun yung ating doctrine of res ipsa loquitur. As mentioned earlier, yung ating case ng Alita, yung sa res ipsa loquitur, kasi there was this question as to whether or not a swimming pool would constitute an attractive nuisance. So also remember yung ating res ipsa loquitur in medical malpractice cases. A recent jurisprudence of 2022 involves De Vera, whereby a patient operated upon for once again, I cannot remember. I'm not a doctor nor an engineer earlier. Can't remember the reason. But there was an operation of a diabetic patient. And the operation of the diabetic patient, what happened later on, the diabetic patient died while in the recovery room. So the diabetic patient died while in the recovery room because there was, as I could remember there, she had difficulty breathing. So sabi nga ng Supreme Court, res ipsa loquitur. the patient would not have died if there was if proper care was given to the patient while she was in the hospital. So kaya yun yung instance na res ipsa loquitur in medical malpractice. So let's proceed to damages now. Damages. When we talk about damages, in terms of your actual damages, always remember that undeclared income cannot be the basis of an award. Short of saying that when you talk about actual damages, it has to be proven. It has to be proven as a general rule. Kasi if it is not proven, aside from those instances, yung actual damages need not be proven. If it is not proven, how shall it be given? If there is damage that is incurred, but it cannot be determined how much is the damage that should be given. What is the amount that shall be given, or what is the kind of damage that shall be given? What shall be given are your temperate damages. Sorry, temperate or nominal damages. I always get confused kung alin sa dalawa. Parang it seems like temperate, pero as we will discuss, we will come to the concept. Pero whichever it is, temperate or nominal, just forgive me if I'm mistaken. As you could see, these slides are just my guidepost kung saan nang sasabihin ko. I do not look at them all of the time. It's just my guidepost for you para alam niyo kung ano yung sinasabi ko. Pero most of the time, ano lang to. It's basing this from memory lang. But anyway, yun na. That's what you have to remember with damages. It must be proven. Otherwise, there is no entitlement to the same. An instance whereby, so yung actual damages natin as compared to moral damages, whereas actual damages have to be proven, moral damages, there are instances whereby it need not be proven. So let's go first to the instances whereby it is required to be proven. Ano yung instances na yun na masasabi natin? Moral damages must be proven in order whenever there is yung classic definition natin ng moral damages. Sleepless nights, anxiety, etc. Yung alam naman natin yan. Physical suffering, mental anguish, alam natin yung enumeration na yan, di ba? Those have to be proven. As compared to what? As compared to those damages which are presumed. Kasi under Article 2219 of the Civil Code, moral damages may be recovered in the following and analogous cases. So meaning to say, you do not need to prove that there is an entitlement to moral damages whenever there is a criminal offense resulting in physical injuries committed against the victim, quasi-delicts, seduction, rape, etc., adultery or concubinage, illegal, you get the point. That is the distinction. That's the reason why there are two kinds of damages, moral and there are two kinds of moral damages, proven and then presumed. So please take note of those. Kaya meron tayong 2217 and 2219 kasi there is a clear reason for the distinctions between the two. In terms of our damages for a corporation, it's not really clear. Sa totoo lang, it's not really clear in this case of Noel Weso whether or not there should be a recovery allowed for corporation because corporation does not have feelings. Corporation cannot be susceptible of 2219 siguro except for malicious prosecution. Pwede siguro malicious prosecution. Pero that is what you have to remember with yung ano natin. So I'll just read that. Temperate, tama ako, temperate damages. Temperate damages are given whenever it is not proven. Kumbaga, these are in replacement or in lieu of your actual damages. An instance of temperate damages awarded may be seen in the case of Meralco versus Hugh. Instance of cutting off electrical connection by Meralco. So, an instance of temperate damages. The damages cannot be proven. Finally, for your exemplary damages, just remember the elements of your exemplary damages. For your exemplary damages, you have to prove entitlement first to actual, moral, nominal, temperate, or even liquidated damages before exemplary damages may be awarded. So exemplary damages as such may be awarded accordingly. And then there must be a proof that they are accompanied by ill will, bad faith, wanton, etc. Yung mga requirements by the law. So yeah, that's thank you for listening to my lecture. I hope that majority of these come out in the bar examinations. I wish you all the best, and hoping, as I always say, I hope that you will never see me again lecture because you have already passed the bar examinations. So thank you and good day.
Ayan. Thank you very much for your very enlightening and comprehensive lecture on civil law. I personally have been refreshed and reviewed on the topics that you have discussed. And I'm also sure our law students and barristers have been refreshed on the critical, salient, and legal concepts on property, obligations, and contracts.
Everything.
Everything na po ng civil law you have discussed. No? But for the part of this program, attorney, we have some questions for you. From also other participants. So here, the first question is, bar candidates would normally have isolate themselves during the review period. And then, so this means that they don't have access to the current issues. No? So would you advise them to still monitor the news, the current news, to keep them abreast with the topics that could possibly inspire bar questions? I think you've mentioned a while ago kanina current issues, diba? The current events that could possibly inspire a bar question. So, what would be your advice on that?
I honestly have personal experience with this one.
Okay.
For those who are not aware, I am the son of the late Dean Albano. My father was known to be the Nostradamus of the bar examinations at the time when he was alive, because he could predict accurately bar questions. Basically, mga 75% of the time he could predict year in and year out. As a result, his materials were always the hot properties during the review season. So when time came that it was my turn to take the bar exams, I hid from my classmates because I know I know lahat tayong mga law students nito, pero my father kasi did not want to kasi it's his way of his livelihood did not want na yung materials niya kakalat sa mga kaklase ko, mga ganun. So sabi ko, okay, sige, isolate na lang ako. Kasi I was an alumni of Arellano. So I studied in my college alumni. Mag-isa lang ako doon. Wala na masyado may kilala sa akin nung time na yan. So nag-isolate ako. Do you know what happened? After 1 week, I returned to Arellano. Kasi I could not take the isolation for too long kasi wala akong kausap, hindi kaya. Hindi kaya ng isolation. So, my advice to all of you, if you're going to isolate yourself from social media. Yun ang i-isolate ninyo sa sarili niya. Pero current events, read the newspaper, kung meron pang newspaper, classmates, okay lang yun. Maniwala kayo, parang it keeps you sane to have your classmates with you, loved one, let's say may girlfriend ka or may boyfriend ka, keep them around kasi it will help you hurdle the bar examinations. Yun ang masasabi ko.
Okay. So I think, sir, no, yung with regard to the current issues, newspaper could be really used by our barristers.
Yes.
Or even, I think we have online platforms naman of our...
Yes. Kumbaga, yun ang point natin, current events talaga.
Current events,
yung kailangan keep abreast with current events talaga.
Yan. Okay. Thank you for that, attorney. Second question naman, could you share any tips on how to study smart during the pre-week before the bar exam?
Well, studying smart during the pre-week actually should start at the regular review level. To say 6 months ago. 6 months ago, you should study all of kumbaga, you should read your book cover to cover. While you're reading cover to cover, you should forecast to yourself what are the important topics that you think can come out in the bar examinations. So that when the pre-week review comes around, meaning to say, like for example, in our case, so September 8, 9, 10, 11, di ba? September 8, 11, and then 15, tama, di ba? So September 8, 11, and 15. You will just refer back to those important points that you highlighted in the books that you are reading. So yun yung tip number 1 ko. Tip number 2, if you can, please avoid using new notes to your eyes. Meaning to say, those notes that you just came across or was just given to you by your bar operations, and then basahin mo to, this will come out. Siguro you could read what are possible tips na, itong case na to, pwede lumabas. Pero, wag yung, ito na babasahin ko ngayon. Hindi, baliwala na yung review material na yan. Parang ganun. Ito na ngayon ang babasahin ko. Do not do that. Do not abandon what got you there in the first place. Yeah.
Okay. Sige po. Nice tips, and thank you for the tips po, no. And then last questions we have here is, could you recommend a smart way to synthesize everything for pre-week without oversimplifying what the bar takers have been studying? I think you've mentioned a few of that kanina. And what for you are the crucial topics that they should focus on during pre-week?
During pre-week? I guess everybody's aware naman yung QAM to, di ba?
Yes.
Yung nilalabas ng UST regarding those areas. That is that's one smart area to focus on, yung mga previous bar questions. And then yung, sabi ko nga, yung may conflict points sa mga law natin. Yun yung magandang i-focus natin. For anybody who passed the bar examinations na who are my students, whether in regular class or in lectures, they know na patok ako pagdating sa bar exams kasi I only focus on the areas that I say to you previous bar questions, and then yung mga conflict points ng mga law natin. So whenever I give lecture, thankfully nagiging patok naman tayo. So that's my tip for anybody who's studying or who will not be able to listen to me. Just focus on the conflict points kasi yun talagang lumalabas. Hindi yung mga objectives na enumeration, hindi yung mga ganun na lumalabas. Conflict points ang iyan mo.
Okay, so yeah, I think with regard to our barrister, they should really reread or restudy all the bar questions previously, and of course yung mga critical topics that you have mentioned on the discussion a while ago. Yeah, so I think that's all the questions we have gathered, attorney. Maraming salamat po ulit sa lecture ninyo on about civil law. Thank you.
Welcome. I hope that I hope that my lecture will be useful to all of you.
Definitely, attorney. It will be very helpful to all law students, not even only barristers, but like me.
Okay. Thank you.
makakatulong po ang ganitong lecture. Thank you again, attorney.
Okay. Thank you.
As I have mentioned a while ago, our lecture today for civil law is just one of the many lectures for the Central Book's Best Pre-Week Lecture Series. As we also have those for political and public international law, commercial law, taxation law, civil law, criminal law, labor law, and legal and judicial ethics with practical exercise. All this happening in September 2024. Please like and follow the Facebook page of Central Books to remain updated with the dates and speakers for each program. We would also like to acknowledge the main sponsor for this initiative, Central Books, and also our main collaborators, PUP College of Law and ALSP National. Ladies and gentlemen, that's it for today. This has been Kyle Roger Agadan, your host for the Central Books Best Pre-Week Ever. Thank you very much and God bless.